If I could please have the recording again. Thank you very much. This is the April 4th, 2022 City of Snoqualmie Land Use Hearing Calendar. And of course, as everyone knows, we are meeting today to begin the hearing, which is the appeal filed by Snoqualmie Community Action Network of the December 2021 City of Snoqualmie Mill PCI Plan Final Environmental Impact Statement. For the record, my name is Sharon Rice. I am an attorney who works as a hearing examiner. I have been appointed by the City of Snoqualmie to provide that service. Pursuant to that appointment, I have jurisdiction to hear and to decide this SEPA appeal. I'm going to run through brief introductory Zoom meeting information for the record and for the attendees and panelists who have not been through a hearing with me recently. After that, we're going to go directly to the procedural conversation, of which I emailed all council an alert before this morning's hearing. So just very quickly, in regard to these proceedings, anyone who needs to get my attention, please do either call me Ms. Rice or Examiner Rice. If anyone in this meeting has requests about how they are addressed, please inform us how we should address you at your first opportunity to speak. Of course, this City of Snoqualmie land use hearing is being conducted remotely via Zoom. It is being both video and audio recorded. To the extent possible, however, I will conduct this appeal hearing just like I would if we were together in Snoqualmie City Council chambers. This Zoom audio recording will serve the function of the required legal, or the audio recording that's required for the legal record, the official record of these proceedings. And so I need your help in this virtual context in protecting its integrity. And I will ask you to do the standard things, including please keep yourself muted when you are not speaking. Please silence your phones to the extent you can make your environment quiet so that we can hear you when you are speaking. If the chat function is enabled, and I don't see it, so that's good. I was going to say, please don't use it for any substantive purpose. I will not be monitoring it. As everyone knows who is here today, in a SEPA appeal, it is the appellant that bears the burden of proof, stating that for the record at the top. Also, as we go through, we will hear first, there will be a procedural conversation, then we will have any pre-hearing motions or discussion that is necessary before we begin with evidence. We will then hear each party's case in chief in order. As we go through, as witness testimony is offered, please everyone remember before testimony is offered and before counsel speaks, I'm going to ask each person the first time you speak to state and spell your name for the audio recording and to state your relationship to the matter. As witnesses testify, I will ask that counsel assist me in being sure they are sworn in before they begin to provide testimony. Of course, remember that there is no public comment period in this appeal hearing, and only persons called as witnesses will be allowed to testify. Currently, we have 5 full days set aside for this appeal hearing, and with luck, we'll complete in these 5 days. It is my strong preference that we do so. I feel like 5 days should be enough to cover the material. If not, we will have to discuss additional dates. As we get towards the middle of the week, we will reconvene on that issue and decide whether additional dates need to be discussed. I want to state for the record a brief description of previous proceedings related to this appeal. After the appeal was received and the hearing examiner, who is a contract service provider with the city, was notified of the appeal, a virtual pre-hearing conference was convened on February 11th, 2022. Following that conference, a scheduling order was issued on February 14th, 2022. And consistent with that order, the city submitted a motion to dismiss for lack of standing. That was largely denied. The applicant submitted a motion for partial dismissal, which sought to limit the scope of issues considered in the appeal to those that were raised in the written 11-page appeal letter. This motion was largely granted. Slight issues were excluded from appellant's motion, applicant's motion, and 1 or 2 issues from the city's standing motion were considered. There was another order or ruling issued following that consideration of those 2 motions that led to today. Also consistent with the scheduling order issued following the pre-hearing conference, there was a pre-hearing document exchange schedule established. Documents have been exchanged, and we are going to discuss the submitted exhibits before we begin with evidence. Please, of course, remember that there was a public open record hearing on the PCI plan application that was conducted on March 30th, 2022. Its record is included together with the record of these appeal proceedings, and all exhibits from both hearings will be consolidated into a single record. Following the conclusion of this SEPA appeal, there will be a single decision or recommendation document issued that addresses both a ruling on the SEPA appeal and also a recommendation to City Council based on whatever that ruling is. As was already announced, any late disclosed exhibits or additional documents that need to be viewed by myself and counsel for other parties need to be sent during the course of these proceedings to City staff person Tom Monroe. Again, his email address is tmunro@snoqualmiewa.gov. All right, I sent you a procedural checklist of things to address before we get started. I listed the first thing there as a discussion of the exhibits, but actually we're going to obviously move that to the end, discuss all the other less controversial stuff first, and come back to exhibits and witness objections. So at this point, what I would like to do at this point is have folks introduce themselves for the recording. So I think we need the first round of attorneys who will definitely be speaking for the parties. If primary counsel for the each party wants to admit their second, that is okay. I'll leave that to you. And we'll go in the same order that we did in the pre-hearing conference. So it'll be appellant, applicant, city. Starting for appellant, can primary counsel please unmute, introduce yourself?
Hi, Audrey Klungen for the appellants, primary counsel.
Thank you so much. And with you, do you want to introduce your colleague?
Yes, we have Dave Brecklin.
Just like to have everybody's name stated on the record at the beginning. Thank you, Mr. Brecklin, for waving at us. Let's go to applicant, please. Could you introduce yourselves for the recording?
Yes, hello, Ms. Examiner. I am Courtney Kaler representing the applicant, and also from my office, we have David Karpman and Jackie Poire.
Great. Thank you all for being here. For the city, please.
Good morning, Ms. Examiner. I'm Bob Sturbank. I'm the Snoqualmie City Attorney. I'll be primary counsel. And with me today is Assistant City Attorney Anna Astrakhan.
Thank you very much, everybody. All right, I'd like to just go through the bulleted list or the lettered list that I sent you on things I think we should discuss at the top. The first was the schedule. Item B is, I said schedule, but it's the order of presentations. Let's just quickly discuss that. I believe we said it was going to be appellant, then applicant, then city. I assume the appellant agrees with that position going first, but between applicant and the city, is there any discussion about that? Ms. Kaler.
Yes, Ms. Examiner, generally, I think that works fine. However, there's some witness scheduling issues and then some particular topics where it may make sense to reverse that order. Sure. So we'd ask for flexibility as between the applicant and the city to take some of our witnesses out of order.
And as I noted in my pre-hearing email, witnesses with calendar conflicts can be called out of order as appropriate. And when there is an issue with either a witness needing to be called out of order or a desire to just change up the order of presentations, if council will just raise that, bring it to my attention, that should be fine. Flexibility is appropriate there. With regard to breaks and timing generally, again, I do sincerely hope that we will be able to conclude all presentation of evidence in these 5 days that we already have scheduled. I believe we agreed to start at 9 each day. It is a marathon here. We do have to pace ourselves. That said, we want to be as efficient as possible. So it was my proposal we run at least 8 full hours, if not 9 full hours each day. I don't know if anybody wants to weigh in on that now, or if what we should do is wait until we get a few days in and then decide whether we need to discuss that. Ms. Klungen, does that sound appropriate?
That sounds fine.
Okay, and then Ms. Kaler, waiting a couple days to see if we need to make for a longer day.
Yes, that sounds fine.
Great, Mr. Sturbank.
Yes.
Thank you. Also, I did, you can see I'm very concerned about breaks. I don't know if anybody else has a bad back from being an attorney and sitting too long, but I have a bad back. So that's why I'm interested in letting you know there will be breaks. There may even be times that I stand during testimony. I have a sit stand desk. So please excuse any mechanical changes you see as if I decide to do that. I do hope that we'll have a full solid morning of evidence, and then in the afternoon we'll have at least a quick break. Regarding lunch breaks, I don't know if you guys want to weigh in. Again, I'm able to be quick. I'm working from home. I don't know where you all are. I don't know if you want to talk now or if we should at each day at lunch decide how long we'll need. Maybe that's how we should run it. Ms. Clungeon, any thoughts about that, or should we just address this at lunch break?
I think we can just address it at lunch break.
We can do that. And Ms. Kaler, Mr. Sturbank, any other thoughts on that?
I generally have no concerns with a shorter lunch break, but also happy to address it day by day.
Same.
Great, thank you. I think we've already said a couple times that if there are any documents that need to be sent, please email them to Mr. Monroe. And I unfortunately, I'm going to get a chime when you do, so please do keep those to a minimum. As I have said in my pre-hearing procedure, I will plan to share my video the entire time so that everybody can tell that I'm paying close attention. If we run into significant bandwidth difficulties, I'm already asking folks to limit video sharing to the person testifying and counsel who is walking them through questions. If we run into trouble, I would suggest first counsel unshare their video, and last that I unshare my video. And just so you know, that's my order of preference if we run into bandwidth difficulties. And I've also, I think, just in case, I don't know if anybody has any questions about my next issue, I want to make this screen as uncluttered as possible. And so I'm going to ask only the two who are testifying to share their video at any one time. And I think that makes sense. We can address that as we go forward. I was just giving you a heads up about that. I think my objections procedure is pretty clear. Obviously, if I have counsel and witness testifying, another attorney wishes to raise an objection, it would be appropriate for you to share your video and state the word objection clearly so that we can hear you. I will ask counsel to make sure your witnesses stop when an objection is raised so that it can be dealt with before we proceed. And last thing was that I wanted to make sure you're clear. I expect to request post-hearing legal briefing at the end of this, rather than have closing arguments delivered verbally. It makes more sense to take the time to put the arguments thoughtfully in writing. And so that's my thought at the conclusion of the factual evidence. We'll discuss a post-hearing schedule. All right. And aside from the discussion of the applicant's objection to some of the pre-hearing disclosed witnesses and exhibits that was seconded by the city, is there any other pre-hearing procedural business that we should address at this time? And we'll start with appellant.
No.
Thank you, Ms. Clungeon. Ms. Kaler, anything for the applicant that needs to be addressed aside from those issues?
To clarify, we have a pending written motion to exclude, and we had reserved the ability to bring further objections at hearing. We do have a couple additional things we'd like to discuss up front, and then of course, reserve the opportunity to object during the course of testimony.
Naturally. So, Mr. Sturbank, anything else, or should we just get to that motion?
The only other thing, Ms. Examiner, would be the exhibits, which in your pre-hearing email indicated that now would also be a time to address objections to exhibits. So like Ms. Kaler, I have a couple of other matters that have arisen in the course of the briefing that we can talk about now, as well as the pending motion.
Yes. So when we turn to the pending written motion to address both exhibits and witnesses that were objected to, that's the next item of business I said are intended to get to, but I do want to acknowledge the city compiled and sent a master exhibit list. And I assume counsel for all parties received that document. In it, the city has noted that noted which documents have been duplicated and has stricken them. For everyone's information, it is my intention to keep the numbering that that was proposed in your disclosed exhibit list. So if an exhibit is stricken because it's a duplicate or because of objection, it will just be, the exhibit numbering won't change. It will just be stricken. With that, I think it's time to turn to the applicant's motion. Ms. Kaler, you said you had some additional discussion on that motion. And obviously, I just want to confirm the appellants have received that motion, of course. Ms. Clendon? Yes.
We have.
Thank you. Okay, Ms. Kaler, please go ahead.
Thank you. So our written motion objects to appellants, the witnesses and exhibits in appellants supplemental witness and exhibit list. So those would be Richard Jack, Jay Hill, Chase Barton, Harold Erland, and Lacey Linney in terms of the witnesses. And Ms. Examiner, I can discuss the exhibits now, or perhaps I should hold that until we talk about all of the exhibits. I think I'll do that latter thing unless you have a different preference. Generally, these witnesses either are raising issues that are part of appellant's case in chief and could and should have been identified in their initial witness list, or they are identified to testify about matters that are not appeal issues. They're not at issue in this appeal. And so I'd like to just run through those witnesses and discuss in particular each one of them. So first, Mr. Jack was identified to speak on toxics remediation, SEPA phasing, and stormwater. These issues, particularly toxics remediation and phasing, were clearly part of appellant's case in chief. They in fact identified a witness on toxics and remediation in their initial witness disclosure, and there is no reason that Mr. Jack should have been held back for rebuttal. Holding witnesses back in this manner, of course, deprives the responding parties of the ability to put their own responding witnesses on, and then an additional week of preparation time between the two witness and exhibit lists for these particular witnesses, and is prohibited by the pre-hearing order, which requires that the second witness list be responsive witnesses. With regard to stormwater, stormwater is not an issue in this appeal. It is not raised in the appeal document as an appeal issue. The only place that the word stormwater appears, and Ms. Examiner, I have a searchable version of the appeal document, so I have looked, is in Sarah Cook's attachment. It's not a standalone issue. It is raised tangentially in the context of one of her claims regarding stormwater. And of course, Ms. Cook is already identified as a witness and presumably will testify regarding her own letter. So Mr. Jack is inappropriate and should be excluded. Jay Hill is identified as testifying regarding water supply and utilities. Again, this is part of appellant's case in chief. They could and should have identified him in their initial disclosure. Chase Barton is identified as testifying regarding flooding and floodplains. And for this witness, flooding and floodplains are not an issue in this appeal independently. So there is no allegation of error in the appeal that raises flooding specifically. Issue 2 in the appeal raised the issue of alleged inconsistency with comp plan policies, one of which mentioned flooding, but that issue has been dismissed. Issue 1A, again, Dr. Cook mentions flooding, but only in relation to wetlands. It's not a standalone issue. It's just part of her claim on wetlands, and she has been identified as a witness. Issue 8, relating to the annexation implementation plan, mentions flooding, but Ms. Examiner, your order on dismissal says Specifically, appellant is not barred from discussing the content of the AIP where the EIS has expressly relied on it. And with regard to flooding, the EIS does not expressly rely on the AIP. The discussion of flooding in the AIP is limited to approximately 1 page. There was not an analysis of flooding in the AIP because the grading plan had not yet been determined. It was not possible to analyze. In contrast, the EIS contains extensive analysis on flooding, including 2 separate computer models, one of which addresses, what they call zero rise analysis, concluding that there will be no increase in base flood elevation as a result of the project. And then the second analysis specifically looks at downstream impacts and concludes that the project will not result in any increased flooding downstream. These are not in the AIP. They are solely in the EIS, and those were not challenged in this appeal, and Mr. Barton should not be permitted to testify on issues that are outside the scope of this appeal. I will note that with regard to all of the county witnesses, those 3 witnesses that I've just discussed, of course, if they wanted to raise issues outside the appeal, they could have testified at the PCI plan hearing. The county did not choose to testify at the PCI plan hearing. It also did not choose to appeal the EIS. The county is not a party, and no particular latitude should be given to county witnesses who have chosen not to appeal and not to appear at the PCI plan hearing, despite knowing that this motion was pending. Moving on to Harold Erland, his testimony relates to wildlife, contamination, wetlands, and flooding. Again, this is a combination of issues that were raised in the case in chief: wildlife, contamination, wetlands, and flooding, which was not raised at all. Ms. Linney is proposed to testify on a range of issues: light, glare, noise, water, flooding, cumulative impacts, infrastructure, housing, and post-annexation implementation plan. Some of these things are part of appellant's case in chief: light, glare, noise, water, presumably that means water supply. Some of them were not raised in the context of the case in chief: flooding and cumulative impacts generally. And some of them were dismissed. So the claims regarding infrastructure, related to infrastructure cost, and the examiner has ruled that economic issues are not part of this appeal. Housing, the allegations relating to housing had to do with affordability and who would be able to live there. And again, the examiner has ruled that economic issues are not part of this appeal. And then the post-annexation implementation plan was restricted, as I previously discussed, to particular issues that were analysis that was relied on in the EIS. So for these reasons, Ms. Linney should not be permitted to testify. Let's see here. We are also objecting to some of the exhibits. I will save that for our discussion of exhibits. And in some, we believe that the examiner should strike all of these witnesses for the reasons I have just identified. If the examiner does allow the witnesses in, then of course, we would like some latitude to call rebuttal witnesses, since we did not have the opportunity to provide a rebuttal witness an exhibit list to these witnesses. Thank you.
Thank you. I think I will hear from the city next, just so that we have all objections raised before the appellants are given a chance to respond. Ms. Kaler, something else?
And yes, apologies. So that's with regard to our written motion. We do have a couple other items to raise. If you want to hear that now, happy to do that, or if you'd like to hear that after the written motion is decided.
And is this related to witnesses also, or is this a separate topic? Okay.
And issues.
Please go ahead.
Okay.
Ms. Kaler.
So we also object to Mr. Derdowski testifying. The items that he is identified to testify on are growth management, comprehensive plan, policy, development regulations, and land use. These are not appeal issues. In fact, for the most part, they are not SEPA issues. Issue number 2 relating to the comprehensive plan has been dismissed. Issue number 5 relates to growth. And we'll note this is different than growth management, which is typically more of a legal issue. That particular issue, issue 5, references only EIS section 1.7.8 and a particular statement in that section that has to do with whether population projections are a cap or not on growth. This is not a SEPA issue. This is a GMA issue. Effectively, this is a retroactive challenge to the zoning here, which is not permissible in the context of the SEPA appeal. Issue 8, again, relating to the annexation implementation plan, was limited on the decision by the motion to dismiss. There's nothing here in these identified items for which the EIS relied on analysis in the AIP. So there's nothing here in Mr. Derdowski's testimony that is a identified SEPA issue in this appeal. Then finally, alternatives. We were surprised to see in appellant's pre-hearing brief the issue of alternatives raised, because again, there is no allegation of error with regard to alternatives. The word alternatives appears in the standing section of the appeal. It appears in the request for relief, but in all of the several pages of identified issues, there's no issue relating to alternatives, and certainly no discussion that would put the respondents on notice of any claim, particular alleged error in the discussion of alternatives. So we ask that, and in addition, there is no witness on the part of appellants who has been identified to discuss alternatives. So for this reason, we would request a testimony regarding alternatives be excluded, and also that those portions of appellant's pre-hearing brief be stricken. And except for exhibits, those are all of our issues.
Okay. All right. We, like I said before, I think we'll check in with the city first so that we have all objections on the table to be responded to. Mr. Sturbank.
Thank you, Ms. Examiner. Just at the outset, I would note that the city joins in the 2 additional objections that Ms. Kaler just raised. 1 to the issue of the reasonableness of the alternatives, and 2 to Mr. Derdowski's testimony. I'll touch on those briefly at the end of my comments. I think the examiner has probably seen in our pre-hearing brief, we did join in the applicant's objections for all of the reasons that Ms. Kaler just stated. I would note a couple points in addition to that. First, with respect to Mr. Hill, as the city pointed out in our pre-hearing brief, Mr. Hill does sit on the King County Utilities Technical Review Committee. By dint of his position, he's the chair, just because that position is under the King County Code, is appointed the chair, but not due to any particular expertise. And the King County Committee has, under its own guidelines and guidance documents, a 90-day period for comment on the city's draft water supply plan update. The county committee, Mr. Hill, have not submitted any comments whatsoever, which means that the Department of Health is free to proceed. And so it would be undue prejudice to the city and surprise to force the city to respond to comments from Mr. Hill in that capacity here today at hearing under oath. And I would note that the city has made attempts to reach out to the county witnesses to determine what the scope of their testimony would be, and they have declined to return calls to discuss that. That's true both of Mr. Barton and of Mr. Hill. And particularly in the case of Mr. Barton, where flooding is not identified as an appeal issue at all, there's simply no way for the city to anticipate or prepare for his testimony, to know what the testimony would be, or to prepare for cross-examination, since there aren't any identified issues in the appeal, nor positions stated there by the appellants, so that we would have an ability to anticipate to what particular technical issues the testimony might be directed to. With respect to Mr. Hill, circling back, also there is a question of whether or not he is qualified to testify on the issues for which he's been identified. Mr. Hill's detailed resume is available on his LinkedIn page. It indicates that he is primarily a land use planner. And while the description, he is not a licensed professional engineer in the state of Washington, so far as we can ascertain, or in California or any other state. The description of his credentials given by the appellants makes it sound like he has worked as an engineer, but his LinkedIn experience describes a very brief period for a consulting firm in 2004 and 2005, his first job out of college. So if they're going to offer him as an expert to testify about water supply and utilities, it appears that he lacks the requisite credentials under ER 702 to be qualified as an expert in that regard. Turning to Mr. Derdowski, the city seconds the objections made by the applicant, and in particular, and in addition, would note that the description of his experience indicates that he also lacks the requisite knowledge, education, training, and experience to qualify as an expert under ER 702. And recent case law makes very clear that the trier of fact needs to determine whether a proffered expert qualifies in that respect, and that must exclude expert testimony unless the testimony satisfies ER 702. And that includes a determination that the testimony will assist the trier of fact and that there is adequate foundation that can be laid for the proffered testimony. And I'm citing here particularly to Lakey versus Puget Sound Energy and the more recent Washington Supreme Court decision in LM by and through Dussault versus Hamilton. It's 193 Washington 2nd 113. That's a 2019 Supreme Court decision. The Lakey citation is 176 Washington 2nd at 918. So for those reasons, in addition to the issue, the bases cited by Ms. Kaler, that there are no of existing EIS appeal issues to which Mr. Derdowski can testify, we'd ask that his testimony be precluded. I think Ms. Kaler has adequately covered the reasonableness of alternatives issue. One final point to note on Ms. Kaler mentioned EIS appeal issue number 5. And I would also point out that the statements in it appear to be a collateral attack on the city's rate of growth as determined by the city's comprehensive plan, policies, and zoning and development regulations. And Ms. Kaler correctly noted that the comprehensive plan issue has already been dismissed, but in addition, case law that's cited in both the city and the applicant's pre-hearing brief makes it very clear that EIS appeals may not be used to make a collateral attack on prior policy decisions. That's the Glasser versus Seattle case, 139 Washington App 728. And as well, case law indicates or establishes that the PCI plan permit process may also not be used to collaterally attack those same prior policy decisions. And that's the BD Lawson Partners versus Growth Management Hearings Board case, Black Diamond matter, with which appellants counsel is very familiar since they represented challengers in that case. That's 165 Washington App 677, a 2014 Division 1 decision. So those are additional bases for precluding dismissing appeal issue number 5, and as well not allowing Mr. Derdowski's testimony related to growth management issues. I think we have other objections the city can cover with respect to individual exhibits on the list. I don't know if the examiner wants to cover those separately now or afterwards.
Let's do witness objections first, and then we'll revisit the exhibit list.
Very good. That concludes my comments on witness objections.
Thank you.
Thank you.
Mr. Bricklin, you have unmuted and video shared. Does that mean you're going to be responding for appellants?
We're actually going to split this up because we have different witnesses involved here, but I'll start. I mean, that was a lot of ground to cover.
Yes.
I mean, overall, I would, kind of the starting point for this is the citizens who filed this appeal were representing themselves pro se, as you know, at that time. And the efforts here should be, and I hope the examiner joins in this, is, to not allow procedural issues to get in the way of fact finding and getting to the substance of the issues. And I would say that that's reflected in the examiner's pre-hearing order, which is not as draconian of a procedural gauntlet as the moving parties would suggest. The pre-hearing order does not require a full and exhaustive disclosure in the first round. It recognizes that the disclosure process is ongoing. Even after the second disclosure, the pre-hearing order says at that juncture, the parties are expected to have substantially disclosed their witnesses and evidence. Even then, further disclosures are allowed for good cause. Even at the hearing, an objecting party must show undue surprise. And if they do show undue surprise at the hearing, the remedy isn't to strike the testimony or the witness. The remedy isn't to shield the examiner from hearing the relevant evidence, but rather to provide additional time for rebuttal. So with that in mind, with those concepts in mind, I want to go back to the some of the specifics. Mr. Barton and Hill are two county witnesses, as you know. They were identified in the second go round. They substituted for Mr. Matthew, who was in the first go round. The substance of their testimony is the same as Mr. Matthew would have submitted to. So there was no prejudice by identifying a different person to cover the same ground. More specifically, the city and the applicant have been well aware of the concerns that are going to be testified to by Mr. Barton and Hill from the beginning. And by the beginning, I don't mean the beginning of this process, but way back when the draft EIS was published, the county submitted comments on the adequacy of the very issues that Mr. Barton and Mr. Hill are prepared to testify about. So, there's no surprise here. They've had this information for over a year, I think. In fact, they were obligated by SEPA to respond to those issues way back then. Now, it may be that they didn't do a very good job of responding and they don't care to defend that inadequate response now, but they hardly can claim surprise with regard to anything that Mr. Barton or Mr. Hill would be testifying to. It is, sort of standard procedure when a party claims foul with regard to disclosures or discovery responses and the like. The courts have admonished, the appellate courts have admonished the trial courts repeatedly that precluding testimony is an absolute last resort. There are other ways to cure issues of that sort other than shielding the decision maker from the relevant evidence. And critical in that analysis is whether the moving party can show prejudice. And there's simply, given that both Mr. Hill and Mr. Barton and the county as a whole submitted these comments, back at the time of the draft EIS, there's absolutely no ability for the moving parties to claim any prejudice or inability to prepare. I'm not going to address at this time the specific attacks on Mr. Hill's qualifications. I think that can be addressed at the time of his testimony, he will describe his background, and the examiner can determine at that time whether he's qualified to speak with regard to the issues that he's going to address. And I guess one more point on that is when we did identify our initial witnesses, the county and city did respond and identify witnesses who would respond to those witnesses. Given that we identified floodplain and water witnesses in the initial disclosure, they were able to identify witnesses to address those topics. There's no reason why they can't continue to rely on those same witnesses, despite the change in the person on our side who's going to present that testimony.
So may I confirm, Mr. Rickland, this means that the appellants are offering Mr. Hill and Mr. Barton in place of Mr. Matthew?
Correct.
Thank you.
Right. And then the other issue that I want to address is the issue of whether floodplains was raised as an issue in the notice of appeal. And it was, and I'd be the first to acknowledge it wasn't done as neatly or as plainly as might have been suggested. But actually, before I discuss that, I do want to clarify one point related to that, which is your ruling on the motion was not addressing the issue of whether floodplains had been raised as an issue on appeal. Rather, the issue at that time was whether a challenge to the AIP was a legitimate part of a SEPA appeal. And we explained, and I think you agreed, that citizens weren't really challenging the AIP as such, but rather to the extent that the EIS relied on the AIP, then the AIP was fair game. But that issue then, and your ruling then, was not a broader ruling as to whether floodplain issues had been raised in the appeal. But the fact that that motion addressed floodplains is indicative of the fact that the respondents did recognize that floodplains were an issue, and in fact they've acknowledged that in the one of the attachments to the appeal that was incorporated into the appeal, the Ms. Cook's letter, there were references to the floodplain analysis being inadequate. The respondents have had ample opportunity, if they wanted further clarification of that issue or detail, they could have made a motion for a more specific statement, greater detail about that. They didn't do that. The examiner's ruling simply required us to disclose exhibits and witnesses, which we did. If they felt that the statement of the issue in the appeal wasn't adequate, along with the witness and exhibit notification, they could have made a request for that additional detail, which they never did. And so I will stop there, and if you have any questions of me, this would be a good time, or we could go on and have Ms. Klungen respond to the rest of the motion.
I believe this question is addressing the argument you've just made, Mr. Brickland, and I just would like a response from the appellant regarding the city's specific arguments that it should not have to respond to the water supply comments for the first time at hearing under oath when the county agency that was cited has not yet issued its comments on the water supply plan. This seems like a pretty sensitive topic, and I wanted to have a response from you on that on the record.
I think they're mixing apples and oranges, if you will. The water supply plan is a separate process from the city, which is a county process, I believe. I'm not even particularly familiar with, to be honest, which is an indication of how separate it is from the issue before you, which is the city's compliance with the State Environmental Policy Act in the publication of this EIS. If they want to, when they cross-examine Mr. Hill, want to suggest that anything that the county has said or done or not said or done in that other process somehow relates to the city's compliance with SEPA in this process, I think that's fair game if they want to try to make some points during cross-examination, if they can demonstrate the relevance of that. But at this stage, I think it'd be extremely premature for the examiner to be deciding issues regarding Mr. Hill's testimony regarding the SEPA EIS adequacy based on what the county did or did not do in some other form.
And so the substance of testimony that's going to be offered by Mr. Hill isn't going to be regarding the adequacy of the supply plan, which has not yet been commented on.
No,
Okay.
it's about the EIS.
Thank you. That was my one question for you at this point. So let's go ahead and hear from Ms. Klungen on the appellant's other responses.
All right. So I believe Mr. Brickland covered a lot of it, and there was a lot to cover. But with regard to just a couple of the witnesses and issues, I just wanted to address. So Mr. Erland, Mr. Erland was identified subsequent to the city, or it was the applicant identified a witness who would speak to wildlife. Wildlife was raised in the appeal. The city or the applicant provided a witness regarding wildlife, and therefore Mr. Erland is in response to that. He is, I believe we're gonna have him as a lay witness, and we have since limited his testimony is going to be more just related to wildlife and wetlands. So those other pieces don't really come into play. Similarly, with Lacey Linney, she is going to address the issues that were raised in the appeal and exclude the ones that the examiner has already has said will not be addressed in the pre-hearing order. So she will have a more limited range of topics based on the appeal or based on the order. So again, it's not a surprise. A lot of these issues were raised in comment letters in the appeal documents. So it is really just an elaboration of information that the city and the applicant have already had. There's no prejudice to her testimony. And then with regard to Mr. Derdowski, I would say that land use is an element of the environment, and we have identified a number of issues, and he is going to speak to those, including the annexation implementation plan as it relates to the EIS. And the city and the applicant, I believe the city has identified witnesses who could speak to that and understand that. So again, there's no surprise there, there's no prejudice, and I would urge the opportunity for the witnesses to speak on this matter.
Question, Ms. Klungen, and I don't know if it's you or Mr. Brickland who should answer, but you're on screen, so I'll ask you. In the applicant's motion, they did note that these witnesses could have, and they argue should have been disclosed in the first round. Do you have a response to that?
Again, I would echo Mr. Brickland's point about, this is a community group who's put this together, despite the draft EIS being released a while ago, the final EIS, and since then it's been a little bit of a rush to get people to speak to a lot of these issues. It was released around the holidays, and then we've since been working on finding individuals who can testify on these issues. And then I would also echo that in the pre-hearing order, there is language suggesting that there could be additional exhibits and witnesses. It was not, you needed to identify everything right away. And after reviewing the applicant and the city's witness and exhibit list, we noted that there were people that we needed to speak to some of these issues that we'd raised in the appeal, that we didn't have confirmation from during the first round of disclosures.
All right. In your comments just now, you've identified Mr. Erland as a responsive witness. The other people were people you didn't yet have confirmation from. Is that what you're saying?
Yes.
Lastly, in the applicant's motion, they expressly call out a document from your traffic consultant, which was dated February and could have been disclosed the first time. Do you have a response to that?
So my response to that is, we provided, or the city and the applicant have Mr. Norris's comments, both the draft EIS and the FEIS. That document was frankly kind of an internal memo outlining what he was going to discuss during his testimony. So we originally didn't think that we needed to disclose that, but in the interest of apprising the parties of the issues that were going to be discussed during the appeal, we opted to include that. So it was to provide extra information beyond what was already required by the disclosures.
All right, and do you have any additional argument or comment in response to both the city and applicant objections to the King County witnesses based on fairness, timeliness of disclosure, etc.?
Again, those witnesses are to an extent replacing Mr. Matthew. So, and then also the city and the applicant have had the county comments, both at the draft EIS and FEIS. There's no surprise, there's no prejudice.
Question.
Yeah.
Will those county witnesses be speaking to the contents of their comment letters?
Yes.
And will their testimony be restricted to the contents of their comment letters?
The testimony will include what is in their comment letters, and to the extent that it applies to the issues that have been raised in the appeal, it will apply to that too. I would also note that the comment letter is included as an exhibit that we provided during the initial disclosure.
Yes. Any other comments on the topic of objections to witnesses, Ms. Klingen or Mr. Bricklin? No.
No.
Okay, thank you. I'd like to sit with that for a moment. I want that to percolate. Can we move on to discussion of objections to the exhibits then? Or did you want to make a responsive comment, Ms. Kaler? I could hear you briefly if you want to make a responsive argument.
Thank you. Yes, if I could briefly. Just kind of running down some of the points that were made. First, with regard to procedural flexibility, I do not believe the examiner has indicated, nor does the city could permit procedural flexibility to raise issues in witness testimony that were not raised in an appeal. As previously stated, the county witnesses had the ability to testify at the PCI plan hearing. They did not. Obviously, the county had the ability to appeal. It did not. With regard to the idea that that two of the county witnesses are a substitute for Mr. Matthew.
Yes.
We did reserve our right to object to witnesses subsequent to the first witness and exhibit list. And the fact that flooding was identified as one of the items that he would testify to does not convert it into an appeal issue. It was not an appeal issue then. It is not an appeal issue now. Mr. Bricklin stated that Dr. Cook's comment letter that I referred to challenged the floodplain analysis, and I will say that is absolutely incorrect. Dr. Cook, excuse me, did not challenge the floodplain analysis anywhere in her comments. This is 100% a new issue that did not appear anywhere in the appeal. Her comments were related to wetlands, not at all related to the analysis of floodplains. That was the specific analysis of no net rise or downstream flooding impacts or anything relating to the substantive analysis of floodplains that appeared in the EIS. Just simply not accurate that appeared anywhere, including in Dr. Cook's comments. With regard to the annexation implementation plan, Mr. Bricklin indicated that our motion related to flooding, it did not specifically. Our motion sought to exclude the annexation implementation plan issue completely because we believed it was a retroactive challenge to the AIP. course, the examiner did not completely agree with us, but we in no way opened the door to this brand new issue in that motion.
Question on this specific point. And I'm just looking at my ruling on the pre-hearing motions. I have not this morning reviewed the appeal document, but in my ruling on the motion and my number 8, addressing alleged appeal issue 8, there is a quotation from the appeal that says the post-annexation implementation plan, which the EIS relies on, is inadequate, and that it does not provide adequate analysis of current site conditions, land use plans, utility systems. This inadequate analysis included such topics as preservation of floodway functions. So that is a place where preservation of floodway functions touches on the topic of flooding and is in the appeal document. That was not dismissed.
Absolutely, Ms. Examiner. And what you ruled was that appellant was not barred, and I'm quoting, from discussing the content of the AIP, where the EIS has expressly relied on it. This was an AIP issue. And as I indicated earlier, the AIP doesn't analyze flooding. The AIP has a one-page general discussion of flooding. It does not include any of the computer modeling that is in the EIS, or really any of the other analysis that is in the EIS. And the EIS does not rely on the AIP. So the issue of flooding is essentially entirely divorced from the AIP. I frankly believe that appellant's original intention was to retroactively challenge the AIP, saying it didn't have enough analysis of flooding, but that's not where we are here. And the flooding claim that appellants were allowed, the flooding claim that they currently want to raise has nothing to do with the AIP. It has everything to do with the analysis that is in the EIS, and that was not challenged in the appeal. With regard to the water supply plan, I'll let Mr. Sturbank speak to that. I do believe it's hard for appellants to say that's not relevant because they've included it as one of their exhibits. With regard to Mr. Erlin and his testimony on wildlife, Ms. Examiner, as you know, the respondents are in a responsive position here. We don't have the burden of proof. Our initial witness and exhibit lists, when they're both due at the same time as they were in this case, we pretty much have to guess about what we think the appellants might identify a witness on. And we therefore identified a witness on wildlife because we thought appellants might. They didn't identify an expert witness on wildlife in their first witness and exhibit list. And to say now that their witness is in rebuttal to our witness really is kind of flipping the burden of proof. If they put on no expert testimony regarding wildlife, there's no reason for us to. And the fact that we were anticipating something that they did not do, doesn't mean they can add somebody late. And in particular, this issue of particular impacts to elk, which I believe Mr. Erlin is going to testify about, was not specifically raised in the appeal. With regard to Mr. Derdowski testifying on land use, and that's an element of the environment. Yes, land use is an element of the environment, but that is not sufficient to make it an appeal issue. Not all of the elements of the environment are appeal issues. They have to be specifically identified in the appeal. Similarly, with regard to Mr. Brickland's comments that the county had submitted a comment letter. The county submitted a comment letter on the draft EIS that was responded to. They submitted a comment letter after the final EIS was published, which is the letter that I believe Mr. Brickland was referring to, and is identified as an exhibit by appellants who will object to that letter. Again, that does not make all of the county's comments an appeal issue. The county submitted that letter and chose not to appeal. And they chose not to show up at the AIP hearing and testify regarding the contents of their comment letters. The fact that there were comment letters that doesn't make every issue raised in a comment letter now an appeal issue. And then with regard to the late identification of county witnesses, because appellants lacked time, the EIS was published and the appeal period occurred in December. It is now the beginning of April. There's really no reason for the appellants to have hung back in identifying these county witnesses until the rebuttal witness and exhibit list. Similarly, with regard to the traffic document, that was in existence at the time that appellants provided their initial witness and exhibit list. I don't think we've heard any reason for it to have been disclosed late, and we request again that it be excluded. Then finally, I heard no response on our motion to exclude Mr. Jack on the toxics issues. Again, appellants had identified that as an issue. They have another witness on that topic. There's really no reason for that late disclosure. So thank you for the opportunity to reply.
Thank you, Mr. Sturbank.
Thank you, Madam Examiner. It might be helpful to step back for a moment, because it sounded like the appellant's response is kind of primarily couched at the outset in the we're a citizens group and therefore we shouldn't be held to the same rules of pleading that everyone else is. And I think the examiner has rejected that in her rulings on the pre-hearing motions. You have to apply the code, as Ms. Kaler correctly points out. The code does not provide for procedural flexibility when it comes to raising appeal issues. And I would note, when you refer to the appeal document itself, it's very clear that appellants know how to raise specific issues when they want to. They challenge the adequacy of the traffic discussion, and the traffic issue has multiple subparts. They challenge the EIS adequacy and the discussion of contamination, and the appeal has multiple subparts and sub-issues. Same for wetlands, same for water supply. Not for flooding. No mention of the challenge to the adequacy of the flooding issue, no subparts, nothing. And all they can try to do is kind of tie back to vague references in an attachment to Ms. Cook's letter and then a reference to the AIP. That's not sufficient under the city code. It's not sufficient under any rules of appellate pleading and identifying errors. I think also falling back on a claim that the appellants are a citizens group doesn't get them there, as the city pointed out and demonstrated in our motion to dismiss. The appellants were represented by counsel, by Mr. Brickland, by Ms. Clungeon. They prepared, the lawyers prepared detailed SEPA comment letter on the draft EIS, and from which apparently many of the appeal issues were taken. They now claim that they didn't represent them, but that seems, as the saying goes, too cute by half. And also, Mr. Brickland himself has been challenging the redevelopment of the mill site for 10 years. He represented appellant groups who challenged the pre-annexation agreement with Snoqualmie Mill Ventures and the city's pre-annexation zoning. And those decisions from the Growth Board are a matter of record. So they're not really in a position now to claim, excuse us, we weren't represented by counsel, when the very lawyers in front of you have been challenging this project for a decade and assisted these particular appellants in their preparation of comments on the draft environmental impact statement. With respect to Mr. Hill and the water system plan, again, I think council's comments to the examiner were not fully candid. On the one hand, council kind of pretended some ignorance about what a water system plan is or what the county's process for approval of the water system plan. But as Ms. Kaler correctly points out, the appellants did list both the water system plan update and the sewer system plan updates as exhibits. Clearly, there's some intention to speak to that process. And then similarly, they acknowledge that the county witnesses, they may ask them about the county comment letters, but Ms. Clungeon did not commit to the examiner to limiting their testimony in that way. So they are intending apparently to solicit testimony on other topics as well. And that's simply not appropriate when some of the issues, i.e. flooding, are not part of the appeal, and the others, as we've pointed out for water, are not appropriate and prejudicial, given that the county has taken no position, has not commented on the city's water system plan. And as Ms. Kaler points out, the county could have but did not comment on the PCI plan, and could have but did not appeal the EIS. So the appellants are not permitted to essentially insert the county as an appellant here and utilize their staff, particularly in a late disclosure environment such as this. Regarding Mr. Derdowski, I'd also point out that unlike the other witnesses identified in the initial disclosure from appellants, they did not, for Mr. Derdowski, identify or provide a CV or a resume. They do not describe any education, training, or experience in the issues for which he's identified. He's not an AICP. He does not have a degree in land use planning. He has not worked as a planner. He, as mentioned before, the examiner is required to apply ER 702 and requisite standards, and Mr. Derdowski does not measure up, and they've made no attempt to qualify him that way. And I think it's telling that their decision not to include a CV or resume from him. Yes, he has experience as a politician. Yes, he has experience as an anti-growth activist, most recently in Black Diamond and previously in King County. And if the examiner did a quick Google search, you'd find even Mr. Derdowski's own blog postings writing with pride about his decision to try to block development on the Sammamish Plateau by preventing construction of roads there that might be needed for growth. So he may be qualified as an anti-growth activist, but he is not qualified as an expert on the topics for which he has been listed. Last but not least, I would point out the Ms. Clungeon's acknowledgement that they didn't list the witnesses previously because they didn't have confirmation is just an admission that their disclosure was late. It does not excuse the late disclosure. It does, I think, indicate their intention to call them as primary witnesses, but for whatever reason, the county's response or inadequate effort upfront by appellants or their counsel, that should not excuse their late disclosure. So I think that covers my responses to what we heard from the appellants in response to the motion.
All right. I am going to hear objections to exhibits next. And what I think I'm going to do is I'm going to hear the objections, and then we'll take a break while I compose my thoughts. And then we will reconvene, and I will announce rulings after a brief break. So with that, objections to exhibits is the next order of business before we move on. And Ms. Kaler is prepared to go. What I'll do is I'll hear from the applicant and then the city, and then when the appellant is responding on the objections to exhibits, if the appellant has objections to city and applicant exhibits, they can raise them at that time, and then we'll hear responses after. So please, Ms. Kaler, objections to exhibits.
Thank you, Ms. Examiner. First, there's a number of exhibits where their relevance is unclear, just on the face of it. There's, for example, many old documents regarding contamination. And so we just would reserve our objection to the extent that those documents are not discussed or the relevance isn't shown. We'll reserve our objection to those. We'd also object to any document that is not discussed by a witness. I have had situations in the past where exhibits were admitted just kind of on a blanket basis, never discussed, and then they show up in simultaneous post-hearing briefing, relied on in ways that was not evident during the hearing, and I'd like to protect against that. And then specifically, with regard to Exhibit S19, this is the county comment letter that was just being discussed. The county did provide comments on the draft EIS. Those were thoroughly addressed in the draft EIS. And in fact, the adequacy of the response to county comments was not identified as an appeal issue. This document is actually a separate comment that the county provided on the final EIS. Of course, comments on the final EIS are not provided for by SEPA, and there's no obligation specifically to respond to them. As noted previously, the county is not a party to this action. Response, the adequacy of the issues raised in their comment on the final EIS, not identified as an appeal issue. And in fact, most of that comment letter relates to topics that are not at issue here. And then finally, the author of that document is Jim Chan. He has not been identified as a witness. Therefore, he's not available for cross-examination, and we would object on all of those grounds. The next document that we object to is S20. This is a newspaper article. In addition to the fact that a newspaper article is an evidentiary, this newspaper article is dated from 2011, and it relates to a dispute over the annexation of this property. So it is really far afield from what's before the examiner now, so we would object to it. The next document we object to is Exhibit S38. This is a fact sheet for an NPDES permit application dated from 2020. This relates to an NPDES permit application for existing uses on the property. It has nothing at all to do with the project or with the EIS, and we'd ask that it be excluded. Exhibits oh, I'm sorry. Actually, I am mixing up my exhibits. The reason for the objection that I just gave is actually related to Exhibit S40. Apologies. That is the document that relates to the it's a industrial stormwater general permit. Exhibit 38, though, if I can go a little bit out of order. We also do object to, this is the document relating to the NPDES permit. It relates to sewer, and sewer issues are not at issue in this appeal. So that is to clarify exhibits S38 and S40. Exhibits S41 to S51, we object to generally, because while these were all identified on the appellant's supplemental or rebuttal witness and exhibit list, they are not rebuttal exhibits. Every one of them could have and should have been raised in the appellant's case in chief if in fact the issues were before the examiner. In addition, specifically with regard to exhibits S41, S42, and S43, those all have to do with the flooding issue. We've discussed that in detail. That is simply not raised in this appeal document, and we'd ask that they be excluded for that reason. Exhibit S44 is the late disclosed traffic memo. We've talked about that and asked that that be excluded. Exhibits 45 and 46 have to do with contamination issues. Again, there's no reason these could not have been provided initially. Exhibit S47 is a site map. It relates back to the industrial stormwater general permit. That's also addressed in S40. And again, this just has to do with existing uses on the site. It does not have to do with the project and does not have to do with the EIS. So it should be excluded. S48 through 50 are duplicates. S51 again could have been disclosed previously. So we're asking that those exhibits be excluded.
Thank you. Mr. Sturbank, I'll hear from you now.
Thank you, Ms. Examiner. The city would join all of the objections you just heard. In addition to the bases for the objections, I would offer a couple additional comments. One with respect to S19, the county comment letter. There's a foundational issue with that exhibit as well, since Mr. Chan is not identified as a witness. And then beyond that, the letter also speaks to a number of issues that are not EIS appeal issues. So for example, it speaks at some length about the county's apparent belief that an interlocal agreement, a past expired interlocal agreement with the city is somehow an issue in the SEPA appeal proceeding or in the EIS, and it's not identified as an EIS appeal issue in any way, nor is there any demonstration that that the agreement is still in existence. So it's an additional basis to exclude the letter. I would also add to the list an objection to S25, which is a collection of well drilling logs from the 1970s and 80s. I think as Ms. Kaler stated, the relevance of the document is not clear. And in addition, there's significant hearsay and lack of foundation problems. There's no method to determine the proximity of the logs that are at issue to the site or any link between those documents and any EIS appeal issue, nor have they identified witnesses who could speak to these documents or lay any evidentiary foundation necessary for their admission. So we would ask that S25 be excluded in addition to the other exhibits that Ms. Kaler has identified, and the city shares and joins in the applicant's objections to those.
Thank you. I will hear from appellants on these objections to exhibits, please.
All right. Again, lots of process. I'll go through it step by step here. All right. Okay, let's start. I guess exhibit S19 regarding the county's comment letter. They've raised the point that it was submitted after the FEIS. The fact that it was submitted after the FEIS does not bar it from being included as an exhibit, particularly when we provided it within the time for exhibit disclosures. It was sent to all the parties. They've been aware of it. There's no prejudice to including this. They say the county is not a party to this appeal, or is the county is not a party. You don't need to be a party in order to testify. The fact that the King County did not participate in the other hearing or appeal does not indicate that they don't have input or comments or meaningful testimony on these issues. About Chan not being the author, or the author not being available, even though Mr. Chan is the author on the letter, it's clearly a collaboration of a number of different departments and groups within the county who were speaking to issues that they had expertise in. So because it was a collaborative effort, we tried to identify county witnesses who spoke to the issues in that letter that are related to our appeal, and related the argument there that there are issues that aren't related to the appeal, such as the interlocal agreement. We're not really addressing that, and so the inclusion of that in the letter is not grounds to not include the entire document. So that would be all right. Again, okay, exhibit 20, this newspaper article regarding the AIP. The AIP is included in our appeal document. The examiner has held that, we can discuss that to the extent that it relates to the EIS. I guess related to S25, the well logs, and the general objection to, unclear lack of clarity about some of the old documents. The basis for that is this is a very contaminated site with a long history, and we wanted to err on the side of including a lot of documents that speak to that, because there's some uncertainty, and our experts need to be able to show what information we do know and what we don't know. And that is an element, that is a huge issue in this case. So what we do know and what we don't know, and a lot of those older records will help fill in the pieces, but they are relevant to the contamination issues that we've raised in the appeal. Related to exhibit S38 for the sewer document. Sewer, we would include that within utilities. We've discussed utilities, water rights, things like that. And so that goes in hand with sewer and water rights and access and the availability on the site. Let's see. 41, I'll go a little out of order here again. 44 about the traffic memo. I already covered that, I think, previously. It was supplemental to documents that have already been produced. There's no prejudice. If anything, it helps and lays out some of the points that we intend to make during the hearing. So it should be included. Let's see. Exhibits, I think 41 through 51, they argued that it was not rebuttal. A lot of those documents, I would point out, are public records. They're publicly available. It's not some sort of internal document that would be a huge surprise. I also tried to include the documents that the expert or that our witnesses might rely on. So that's why they were included. And I believe a number of them were referenced in various comments on the draft EIS, FEIS. They include references to these documents. So I included them so that we would have the full record in case they wanted to point to any of those documents during their testimony. And then 47 regarding the site map. I just need to take another look at that, but I believe that was in the context of, let's see here. So this is related to, it's a site map, but it contains information regarding fill. And then it would be related to contamination, understanding the hydrologic issues and connections on the site. So that was why we included that. And that is related to issues that we've raised in the appeal. So for those reasons, all of these exhibits should be included. There's no prejudice. It's not a surprise in any way. So. All
right.
Response.
Okay, thank you. Any final comments in reply briefly from either the applicant or the city?
I'll try to keep it very brief, Ms. Examiner. This is Courtney Kaler again. Specifically with regard to Exhibit S19, the fact that there's speculation that this was a collaborative effort internal to the county doesn't change the fact that the author of the document is not here. Most, if not all, of that document is irrelevant. Appellants have indicated they're not relying on those parts, but they have not identified which parts they are relying on. The Exhibit S20, it doesn't relate to the AIP. It relates to annexation. It's dated in 2011. It's not relevant. Exhibit 25, as with many of those old documents, we would reserve the right to object to if there's no apparent relevance during testimony. With regard to Exhibit S38, the word sewer does not appear in the appeal, with the exception of Appeal Issue 6A. Appeal Issue 6 says the FEIS does not adequately describe the impact to available water demand for the proposed development. And then the only time the word sewer appears is a quote of King County Code Title 13, Water and Sewer Systems Code states, it goes on to quote something about water supply. So that is simply the title of a King County Code chapter. There are no issues at all about sewer supply raised in this appeal. With regard to the comment that these documents listed in rebuttal are all public records, therefore no surprise. There's obviously many documents that are public records, and many documents that were included in comments on the draft EIS. That does not make them appropriate for exhibits. In this matter, I believe it was Exhibit 47, the site map relating to hydrologic connection. Again, that is not what that document refers to. It refers to the current industrial stormwater permit, which has nothing to do with the project. So we would again ask that these exhibits be excluded. Thank you.
Thank you. Mr. Sherbank, anything briefly?
Thank you, Ms. Examiner. Yes, very briefly. On S19, the county letter, again, I think we heard an acknowledgement from council that there are a number of things in that letter that aren't relevant to the appeal, and therefore the letter shouldn't come in. If they do have, if the examiner does decide that some issues are appropriate and witnesses testify, then they can testify to those particular issues. We shouldn't have a document that comes in that, as Ms. Kaler pointed out, then raises the risk of being cited later in simultaneous post-hearing briefs suddenly for an issue that wasn't the subject of testimony, but it's in a letter, and so then it gets pointed to. I think the acknowledgement that you heard from council is actually supports excluding S19. S25, again, no explanation as to how those particular documents relate to the site. In fact, there's not even the statement made that they are on the site or anywhere close to it. They would need significant evidentiary foundation to support admission of that document, and they don't have anyone listed who would have those qualifications. And the one person who possibly maybe could have, Mr. Matthew, is not going to be called. So without any representation that any of S25 actually relates to the site, it should be excluded as lacking foundation. And then I particularly would join the objection to the sewer related document. Again, sewer is not an appeal issue at all anywhere. And the one issue, 6A, I think, in which the reference appears is in a statement about the water system plan and about the applicability of the King County Code provisions to the lifespan of a water system plan, not of the city's general sewer plan. So the sewer related exhibits should be excluded as well. those are the remainder of my comments, and thank you.
Thank you. Thank you. All right. Rather than trying to respond off the cuff, I'm going to take a couple moments to look at the documents objected to and compose my thoughts. So I propose we take a break now, and that I will come back at 11, and we begin at 11. So get some coffee and stand up. I'd like to pause the recording, and we will come back on at 11. Thank you.
Thank you.
Thank you for recommencing the recording. I appreciate the arguments and the issues that were discussed. I'm going to attempt to make some coherent rulings on the objections that have been raised. First of all, I'm going to, as a blanket rule, overrule the objections based on timeliness of the second disclosure. It was, as I indicated in the pre-hearing conference, and as I wrote in my my scheduling order, documents and witnesses that were disclosed by March the 16th, which became March 18th, were to be considered timely. Anything submitted after that was subject to a showing of good cause. So I'm not going to exclude on the grounds of timeliness. I'm attempting to address these objections as a blanket issue. The issues that were dismissed in my ruling on the motions remain dismissed. Therefore, any testimony on comprehensive plan and economic impacts, and any testimony about issues that aren't explicitly stated in the appeal must be excluded. So that includes, there is not an explicit statement of error with regard to stormwater, with regard to sewer, or with regard to flooding in the appeal document. And therefore, those issues which were not sufficiently clearly enough raised in the appeal to perfect the appeal as to those issues must be excluded. Attempting to translate that into making sense of the exhibits and witnesses that were offered, it's my understanding that Chase Barton was offered solely to address the issue of flooding. And because I am finding that flooding is not an issue in the appeal, we do not need testimony regarding flooding or floodplains. With regard to the request to strike specific exhibits, without having time to closely read each one in light of the arguments that were made today, the only document I saw that strikes me as really not being relevant is the Seattle Times article at S20. There's very little hope of being relevant, and I will strike that exhibit. With regard to explicit admissions of the objected documents, I am explicitly admitting S44, again, because I've overruled timeliness as an objection. So S44, the February comments of appellant's traffic exhibit, is explicitly admitted. Blanket ruling attempt here. The applicant's motion to, or intent to request that any exhibits not be spoken to by a witness, and the portions of exhibits that are not spoken to by witnesses, having those be stricken. I'm going to attempt to rule on that on an exhibit by exhibit basis as we go through. So those documents that I am not currently striking, but will strike if they become clearly not relevant, if they are not spoken to, or if other grounds for their exclusion are successfully raised in the course of testimony. That includes S19, S25, S38, and S41 through 43, and S45 through 51. So that didn't pare things down very much. I remain, it's a little strange to have county witnesses testify at this hearing, but I agree with appellants that the fact that the county did not appeal does not automatically render county witness testimony irrelevant to the appeal issues. I remain sensitive to the city's concern that any testimony it receives concerning the water system plan under oath has strange ramifications for its city's water system plan process. And I believe I extracted a response from Ms. Clungeon that the witnesses aren't to be testifying on the separate process, but only on FEIS issues. And so I'm not going to strike the county witnesses at this time. I do, of course, expect there will be objections during testimony, and I will be considering those as they come in. If I find any of them are persuasive, I will be striking or limiting testimony as we go forward. I believe that covers all of the pre-hearing motions.
Can I ask for one clarification?
Yes.
This is Dave Brecklin for the record. As you noted during the oral argument on the flooding issue, the appeal, the notice of appeal does make specific reference to the issue of preservation of floodway functions. And I heard you say that you didn't think that flooding as such was an appeal issue, but I'm wondering, were you intending also to preclude the discussion of floodway functions? I'm not sure how the two differ, but given that the appeal did make specific reference to preservation of floodway functions, I would hope that would still be part of the appeal.
So,
Mr. Examiner.
yes, I can hear from you, Ms. Kaler. Go ahead.
Thank you. I believe, and I am checking here, that that reference that Mr. Bricklin is referring to has solely to do with the AIP, and your prior ruling on the AIP was that appellants could discuss the AIP, but only to the extent that, and I'm just getting the exact language here, appellant is not barred from discussing the content of the AIP where the EIS has expressly relied on it. And as I discussed earlier, the AIP does not, the EIS does not expressly rely on the AIP with regard to flooding at all. And so, and Mr. Bricklin has not pointed out any other place in the appeal that he's referencing. And so therefore I believe that flooding issues, Mr. Examiner, as you have already ruled, should be excluded, and would also request this particular item not be re-argued.
If I may respond that just very briefly. So I think we're all talking about paragraph 8 of the appeal, and it begins with a reference to the AIP, but the next sentence refers to the pre-annexation agreement. And the last sentence, the one that includes the floodway functions reference, says that there's this inadequate analysis, and the respondents are attempting to tie that last sentence back to the first sentence. The AIP is not at all clear that that's what the pro se litigant meant when they referred to the inadequate analysis covers topics such as floodway functions and other things that are mentioned there, cleanup, et cetera. I believe that the intent was, I know the intent was to include, was to say that the analysis in the EIS on all those topics was inadequate, in part because it relied on this post-annex, the AIP, and then they made the point that all these issues had to be addressed per the annexation agreement. Well, of course, they also had to be addressed pursuant to SEPA. So I believe that was clear enough. And again, I would point out that while as counsel for the city has indicated, I see he wants to get a word in here too, that as the counsel for the city has indicated, yes, our firm has been involved on numerous aspects of Snoqualmie issues for many years, but we were not involved in drafting this document. I think the document was signed by the lay witnesses, or lay citizens. It was prepared by them, and that they were not as careful with their language. I understand that the rules apply to everybody, but you also need to try to understand what the intent was of the words that they used. And I think it's pretty clear that the intent was that the floodway functions piece of the EIS was not adequate.
Understood. Yes, I will hear from Mr. Sturbank.
Thank you, Ms. Examiner. I mean, it appears like we're going into re-arguing
Yep.
the objection, and that further that Mr. Bricklin is trying to testify about the intent of his clients when he said that he didn't draft the document, but he's going to offer hearsay testimony about what they were thinking, which is just inappropriate on a number of different grounds. And further, I would say that the explanation that he just provided, I do not believe was the explanation provided in their response on this motion. And in any event, the examiner already ruled that this related to the AIP, that the AIP is out, except to the extent that the EIS relies on it. And you know, last but not least, I think that the intent argument that was offered is untenable in light of the language, the plain language of the paragraph, which says the AIP is inadequate and that it does not provide adequate analysis. And then later goes on to say this inadequate analysis, it's referring to the AIP analysis that's identified at the outset of the paragraph. There's no reference to the adequacy of the EIS analysis.
Let me jump in. The reason that I am being persuaded that flooding should not be included among the issues in the appeal, despite my conversation during the motions argument earlier, is based on my overarching ruling in paragraph 5 of my ruling on the motions, which was that the Snoqualmie Municipal Code requires notice, fact pleading, not notice pleading. And the appeal's one reference to preservation of floodway functions is not sufficient to apprise the parties. So what I said in my ruling was that the scope of the instant appeal proceedings should be limited to those issues as stated in the appeal letter that are sufficiently specific to apprise the parties of the factual basis upon which relief is sought. And because that's the sole reference to floodway protection, I'm now deciding that that is not specific enough to apprise the parties. So I'm gonna.
Well, although I'm hoping you're also taking into account the numerous references that in the attachment to the appeal notice. So it was not just that one statement in the body of the notice, but Dr. Cook's document also made multiple references to the floodplain.
You know
issues.
what? Let me do this. What witnesses are the appellants starting with?
Well, we were going to start with Mr. Barton, but if you want to take more time on this, we can juggle that around.
Ms. Examiner, I'm really going to object to the re-arguing of this motion here. Mr. Bricklin already identified the comments of Dr. Cook, and I think it's quite telling that he is not identifying any specific area in her testimony where this issue is raised. I can tell you again, I have a searchable document and I have looked at every single area where flooding, the word flooding or floodplain is used. There is absolutely nothing in Dr. Cook's letter that challenges the floodplain analysis or the modeling that was conducted as part of the draft EIS. Dr. Cook's letter addresses two topics, contamination and wetlands. And those are the only contexts in which those words are used. They absolutely do not have to do with the topic that Mr. Bricklin is suggesting.
I'd just like to note for the record that your examiner does not have searchable copies of documents, and that seems to put her at a great disadvantage. And because this is true, I'm going to invite the parties to send via Mr. Monroe searchable copies of the appeal documents, the appeal letter and its 5 attachments. I'm going to reserve ruling on this issue on floodway inclusion until after lunch. We're going to have the appellant start with another topic and witness. Mr. Sturbank wants to weigh in on my ruling.
The ruling is just fine, Ms. Examiner. I was just going to point out, for the benefit of the parties, that the applicable case law establishes that it's the obligation of the party making the argument to provide citation to authority and places in the record. It's not Ms. Kaler's nor my obligation to disprove. It's the obligation of the appellants to prove that they raised flooding. They haven't done that. And I think the searchable copy that we will get to you quickly will establish that.
Again, I'm going to reserve on this one topic then. I have taken under advisement this argument. I'm going to reserve ruling finally on this one topic of whether or not flooding is adequately raised in the appeal. You've heard both sides of my thinking on that. I will come back after lunch and we will get a final decision on that. The other rulings are as stated. And I'm going to ask if, aside from that, are there other clarifications requested, or can we start with evidence?
I'm not
Mr.
sure I heard a
Senator,
ruling with respect to Mr. Derdowski as a witness.
You didn't. With regard to the issues that are stated as being covered in Mr. Derdowski's testimony, growth management, policy development regulations, and comprehensive plan do seem to be outside the scope of a SEPA appeal. I don't know what's going to be argued under the heading of land use. And because I don't know, I had not decided to strike Mr. Derdowski as a witness. And that is what I had to say about that.
Ms. Examiner, if I could just be heard again very briefly on flooding. Dr. Cook is a witness, and
Yes.
we're not objecting to Dr. Cook. She can speak to anything in her letter. These are very different topics, very different experts. And if Dr. Cook wants to discuss her mention of flooding in the context of wetlands, which is how it was raised, we're not objecting to that. What we're objecting to is the introduction of an entirely new issue, which Dr. Cook not only didn't raise, but is not qualified to raise or address, and the inclusion of an entirely new witness to address this topic that has not previously been identified.
Okay, thank you. Your point is clear. With city and applicant counsel muted, I think that means they don't have further argument they'd make at this time. And no other requests for clarification. Okay. With that, it is 11:20. I feel like we should get started with some evidence. Could I please have appellant's counsel let us know, are you ready to proceed?
We are. I'm going to hand the baton over to Ms. Clengen for our new first witness.
All right. Our first witness is going to be Pam Jenkins.
Thank you very much. So Mr. Monroe will be promoting her. Thank you very much.
Am I connected now?
You are connected. We can hear you. Are you able to share video?
Let me see if I can figure that out.
Little camera in my screen. It's the little camera in the lower left corner, and there's an up caret next to the camera.
I don't have a camera on mine. Perhaps somebody could facilitate that from master control.
I don't believe so. That's an option I think you have to select to
Okay,
share
let
your
me see
video
if
or
I can
not.
find it.
It's fine, Miss Jenkins, if you don't have video, it's fine.
Apologies, we allowed her to speak as an attendee, but I just sent her promotion to panelist thing, so then that should help.
That should take care of it. Thank you. I was wrong, Miss Jenkins.
No problem. I'll just wait until they can connect, because I think there's some value to seeing that I'm a real life human being with.
I agree. I'd be happy to see you as you testify. That was my intention. I'm just saying, in the event that we have a witness who doesn't have a camera, we can proceed with their testimony without a camera. So I can see you now. Ms. Clenchen, would you like to introduce your witness, or shall I just ask her to introduce herself?
I'll allow Pam to introduce herself. That's
Great.
Pam.
I'd like to ask you please to state and spell your name for the record, and then please give me whatever title by which I should identify you in the findings, and then I would like to swear you in.
All right, my name is Pam Jenkins. First name spelled P-A-M, last name Jenkins, J-E-N-K-I-N-S. I live in Wenatchee. And what else did you need to know?
A title or
Oh, you can call me Pam. I think I'm the only Pam among the witnesses, or
All right.
Ms. Jenkins will be fine.
just you know, I will be calling you Miss Jenkins. It's not my practice to use first names during hearings. I just wonder, do you have credentials that I should identify in relation to you with regard to your testimony?
Yes, I do. I'm an environmental engineer. I have degrees in mechanical engineering and in civil/environmental engineering,
Okay.
and about 38 years experience in the environmental field.
I'm sure Ms. Clenchen will walk you through some of that. Allow me please to swear you in at this time. Would you raise your right hand? Do you swear or affirm your testimony will be true? If so, please say I do.
I do.
Ms. Jenkins, thank you very much. Ms. Clenchen, please go ahead.
Right. Hello, Ms. Jenkins. Good morning. How are you?
I'm good, thank you.
Good. All right, so kick things off here. I would like to start. I'd like to offer exhibit 15, which is Pam Jenkins' CV. Okay. And Pam, I'd like you to just tell us a little bit about your background and walk us through your CV and experience here.
Okay, well, I just mentioned that I have 2 degrees, Bachelor of Science and Master of Science in Engineering. I have 38 years experience in the field. And that field experience, which I think it really is more telling than what I learned in school, includes involvement in probably 40 or more environmental site investigations, contaminated site investigations in both Washington and Alaska. That included preparing sampling plans, data analysis, doing field work, writing in remedial investigation reports, and feasibility studies, which have to do with figuring out what sort of remedial actions may be best for a particular contaminated area. And in some cases, preparing the actual remedial action plans. I've also been involved in preparing technical permit applications for 7 mixed nuclear hazardous waste facilities at the Hanford Nuclear Reservation. And because of the nature of the waste that was proposed to be processed or stored or disposed of in these facilities, it required an extensive knowledge of the type of waste and its potential impacts on the environment. In addition to that, I've also done a lot of comprehensive environmental compliance assessments at federal facilities in Washington, Alaska, Nevada, and Massachusetts, which is only really relevant in terms of just knowing the rules very well for both storage, handling, and disposal of hazardous waste in particular.
Okay. All right. And what was your task in this project?
I reviewed primarily the portions of the draft EIS and the final EIS that have to do with known and suspected contaminated areas within the project site. And so I think what might be most helpful is if I first maybe walk Ms. Rice through a brief overview of what's what on the site, so that if I refer to a particular contaminated area or suspected contaminated area, there's some cognizance of where that may be in relation to the rest of the site and to any sensitive areas. Would that be appropriate?
Yes.
Okay. I think what might facilitate this is if we can speak to a particular figure. I'm not sure I can do a share screen, but it is, there's an exhibit or a figure in the draft EIS on page 250, no, on page 3-144, and I think that is PDF page 255, if you're bringing up this document online. And yeah, unfortunately, I didn't write down the document number, but it should be obvious.
What was could you provide the page number again?
The
draft
page number in the draft EIS is 3-144 or PDF page 255.
Okay.
And this figure is entitled Site Plan Showing Areas of Known and Suspected Contamination, Snoqualmie Mill Property. And there's a lot in this figure. It may be helpful even if you're bringing it up on screen to expand it. Otherwise, I can't read the tiny.
I can share it for you.
Awesome.
1 second. Let me know if you're able to see it.
Yes, should I proceed?
Yes.
So there are 3 planning areas that are discussed in the EIS, planning areas 1, 2, and 3. This is a large area. What's included in the red boundary is, I believe, 261 acres. So planning areas 1 and 3 are both roughly 100 acres each. Planning area 2 is obviously smaller. And in the report, in the EIS, it explains that a certain portion of planning area 2 has not been annexed into the city of Snoqualmie. So it's, if it were, the total polygon there, I believe, was 56 acres. Currently, the area within the city is 40 acres. So what's being considered, so I'm going to move now to talking about specific areas of known contamination within these sites. So I'd like to start with planning area number 2, which is up in the northeastern corner with the magic hand waving at us. So let me also just provide a little bit of background about the facility itself. Weyerhaeuser began operations on this property in 1916, and they operated the mill until 1989. So that's some 80 plus years of operation. They had some activity still on the site until 2003, when they actually closed everything down. So, and there's lots of similarities to this site to other former mills within the state of Washington, in terms of how their operations were done, and also in terms of what sort of waste materials were generated and the types of contaminants that are relatively common to the common operations at sawmills and pulp mills. This was not a pulp mill, so that doesn't apply. But the remedial investigation, I think if we were planning a new comprehensive remedial investigation, drawing from the experience at other mill sites such as the Port Gamble Mill up in on the Kitsap Peninsula or Hood Canal would be relevant. Also, there's a mill near where I live in the town of Kashmir that was just a sawmill as this site was. Both of those other sawmills are examples of, I think, the complexity of sawmills and the potential for contaminated areas in lots of different locations on the mill property. And let me also say, and that the EIS is clear about this, that there has never been a thorough remedial investigation conducted on this mill site. There have been, let's say, sporadic attempts at remediating contaminated areas that were discovered. Much of that discovery has relied on the memories of former employees at the Snoqualmie mill who knew something about, for example, when the plywood plant burned to the ground in 1989, which caused a number of different contamination situations in planning area 3, which we'll talk about in a bit. But relying on employees' memories doesn't necessarily give us a comprehensive look at what actually occurred on this site that may have resulted in contamination. So we have a partial history here of contamination and a history of partial remediation. And I'm going to talk about that in a little bit more detail as we go. Let me also state this in a general sense about the site. The site was recently evaluated by the Individuals in Ecology's Toxics Cleanup Program to rank it according to the Washington ranking method for contaminated sites, which is a key part of the MOTCA process, MOTCA meaning Model Toxic Control Act. So a skilled toxicologist went through all of the known information about the site and what's been identified there already, and went through the various steps of evaluation and ranked this, thank you, a level 1, which is the highest level or most serious level of contaminated site among all of the 13 or 14,000 sites that have been identified within the state. So
Can I just jump in, Ms. Jenkins, and ask Ms. Klingen to tell us what document she's showing now?
Yes, just to clarify, I've pulled up scan exhibit 4 and 5, which relates to her discussion of the site hazard assessment.
Thank you for that. I just need to have the documents that are being testified to stated for the record. So that's why I interrupted you. I'm sorry, Ms. Jenkins, please go ahead.
No, thank you, it's fine. So this evaluation said that this site is contaminated. What is already known about the contamination at this site already puts it in the highest category, which means the most serious, most contaminated / highest risk of all the contaminated sites within our state. For comparison, other sites that have been ranked in level 1 include the Midway landfill between Seattle and Tacoma, Western Processing, the Tacoma Tide Flats, the Cedar Hills landfill, and there are many others. But the implication here is that this is a seriously contaminated site, and that contamination cannot be taken lightly, particularly in view of the plan for future development here. And it makes sense that the contamination here be very well understood before any sort of future development actually begins. It's very risky to start developing a property where there is a high suspicion of contamination because of the event of the potential for exposing construction workers, even at the sort of beginning excavation stage. You could expose construction workers, unbeknownst to them, to contaminants that become airborne from soil that they breathe in without even realizing that they're being exposed. And there are a number of extremely serious contaminants on this site where that situation needs to be avoided. So there's no question in my mind that a thorough, complete remedial investigation needs to be done in all 3 planning areas. So in the draft EIS, there is a summary of cleanups or partial cleanups that have been done in some, but not all, of the known areas of contamination on site. And the developers consultants, Fairlawn Consultants, did a small investigation within planning area 1, which I will also talk about later. But let me just walk through some of the key known areas of contamination, just to give some overall familiarity with the site, if that's okay. Now, Ms. Rice, if you're already familiar with this, I don't want to waste your time, but if you think this would be of value, I'll go forward.
Please go ahead.
Okay. So let's start at planning area number 2. There are in the northeastern corner, thank you, magic hand. And there are 2 known areas of contamination in this area. And you'll see little arrows here to smaller outlines or boxes. There's the lumber strapping area just west of a long rectangular building footprint, and the transformer T18 area just to the east of that same building footprint. So in the lumber strapping area, what I understand of lumber strapping is that could either be strapping together layers of plywood for, plywood is made from thin strips of lumber, which then are glued, pressed, and then heat pressed. That may be what the strapping area was for, or it could, and this is what I think is more likely based on its location, could have been for finished lumber, finished product that was being strapped together for shipment. We don't know from the information that I have seen. But at any rate, what was found in this area were diesel and oil range hydrocarbons that had been released to the ground from whatever the operations were here. So that was probably the equipment used that pressed these pieces of plywood together, and or simply the transport vehicles that were taking these products to market. So the diesel and oil range hydrocarbons that were released to the ground were found both in soil and in groundwater at this location. So there was about 750 cubic yards of soil excavated from this area in 2005 and 2006, and apparently disposed of at the hazardous waste landfill in Arlington, Oregon. In the transformer, so what we don't know is about the lumber strapping area is, did they get all of the contamination? And what is the remaining impact of that contamination on groundwater? That's always a concern, is what remains after the remedial action was performed. The transformer T18 area was discovered because there was staining underneath, well, on the concrete pad. And this was a huge transformer outside of this building. And records indicate that it was not a transformer that contained PCB. But petroleum hydrocarbons were discovered in soil samples around and below this transformer that were above what are now current MODCA cleanup standards. And I think they dug down 10 feet below ground surface in the same area, but didn't find that the contamination had gone that deep. So they excavated, according to records, it quoted or relied on in the IS, that there was about an 85 square foot area here that was excavated to about 3 feet deep to remove the contaminated soil. Roughly 10 cubic yards of soil were stored on the mill property, which was not the total, by the way. So I suspect, even though the information is not complete here, I suspect that the most highly contaminated soil was shipped offsite and hopefully disposed of at an appropriate facility. And then some of the less contaminated soil was retained on site and treated in biocells in one of the buildings on the mill, within the mill area. So, and that on-site treatment was probably much cheaper in terms of a treatment method. Because that soil, when there's an excavation, pretty obviously, you need to refill the hole that's left behind because the hole itself is a hazard. And so I think they were probably thinking it would be great if we could treat this material on site. Once it is shown to be clean, then we'll refill the excavation where it came out of, or use it as fill somewhere else on site. Unfortunately, the records that were reviewed did not, or that were found, did not give us any additional information as to the ultimate disposition of that less contaminated soil that was apparently treated on site in the biocells. The biocells are simply a place where they can allow, either inject the soil with organisms that will essentially feed off of the contaminants, the organic contaminants, or use soil that has a sufficient amount of such organisms already, or it doesn't necessarily have to be organisms, but there are preferable temperature conditions and chemical conditions that enhance the natural attenuation of petroleum hydrocarbons in soil. And so a biocell is designed to sort of perfect that environment for the natural degradation of petroleum contaminants. So according to the draft EIS, there were no other investigations regarding potentially contaminated areas within planning area 1. So let me just underscore that there are still unknowns. So let me move down south here to planning area number 3. This part of the campus, if you will, the mill campus, was the location of most of the historical sawmill operations. It also contains most of the known areas of contamination. And contaminants found within planning area 3 include petroleum hydrocarbons, PCBs, which stands for polychlorinated biphenyls, heavy metals, and likely dioxins and furans, which, by the way, were not mentioned in the EIS, to my recollection. There is a wood debris fill area in the northwest corner of planning area 3. And I think it may be that lighter colored area in sort of the stovepipe right there, yes. Although this area is not specified on the as a contaminated area. But a single sample, one sample from this area was obtained in 2004 and apparently analyzed only for diesel and oil range hydrocarbons. That one sample did not show petroleum contaminants above MOTCA method A cleanup levels. But let me just underscore that that is not a complete investigation. Taking one sample from an area where there has been a history of buried material. And I'm sort of confused why anybody would do that. But I just wanted to point that out because my impression of this site is that because there has not been a comprehensive remedial investigation, there's been sort of a shotgun approach. It's like, oh, we're out here sampling today. Let's just grab a sample from this buried material and see what we find. And I'm here to say that one sample from an unspecified volume of buried material tells us anything. It has no value in my mind in terms of a scientific investigation of a potentially contaminated area. And I'm sorry to say also that that's not the first time I'm going to say that. So getting onto a better known area of contamination, there down in the tour, if you go due south from that, yes, keep going down here, there's an area identified as transformer T12 area. Keep going right here, a little bit further south. Oh yeah, there's T12 and T17. So there are two transformers that were located. These again are huge transformers that were located outside of the plywood plant. Now, I'm guessing that plywood plant may have had more than one building, just because it looks like a building outline on this diagram, but the transformers were reported being outside of those buildings, and that makes sense that they were outside, partly because of their size, but also because of their function. So the building burned to the ground in 1989, which actually was the end of Weyerhaeuser's production of plywood from this mill. 3 PCB transformers were located just outside the building, and 2 of them showed evidence of leakage after this fire. So an investigation was done. I'm sorry, I don't remember when, but after 1989. But I believe before MOTCA levels had been established, which was probably for PCBs in the mid-90s. So 2 of these transformer areas or transformers themselves showed evidence of leakage after the fire. So groundwater samples and soil samples were taken near the locations of both of those 2 transformers. PCBs were detected in both media, both groundwater and soil, at levels that are above our current MOTCA method A cleanup levels. The contaminated soil, and even if those, I don't know exactly in 1989 what guidance they were following, but both EPA and possibly state of Washington had guidance levels at that time, which had not been fully incorporated into the, well, in 1989, we didn't have MOTCA yet. So, so these were probably guidance levels prepared by EPA. So at any rate, the PCB contaminated soil was excavated. We were not, the material, the report that was referenced did not indicate where the soil was disposed of. So later resampling of soil after excavation near transformer 17 showed PCBs were no longer above the EPA cleanup level at the time. To my knowledge, there has not been any resampling at that area. PCB contaminated soil was also excavated from the area near transformer T12, which is at the south end of that presumed building outline. As the excavation of that contaminated soil was going on, whoever was overseeing the excavation noticed that the that the excavator was beginning to dig into a layer of clay that was underlying the more granular soil above it. And so they chose to stop the excavation at that point, even though it was apparent that the PCB oil went to that level. The reason was that the reasoning there was that that clay layer would act as a natural barrier for further migration of the PCBs downward in the soil column. And because the generally speaking, let me back up a little bit. Generally speaking, they have found two aquifers at this site: a shallow aquifer bounded on the bottom by a clay layer, and then a deeper aquifer so I don't remember exactly the geologic profile here, but in very simplistic terms, that's what we have. So I think there was some wisdom to halting the excavation at this point so that there would not be penetration through that clay layer that could perhaps allow the contamination to go deeper into that lower aquifer. Now, whether that would be done in a similar way today is a big question mark. But this site was revisited in 1991 to place a geotextile membrane, basically a plastic cover, over the area where contaminated soils had been removed and where possibly some contaminated soils may have remained in place. The report showed that this geotextile membrane was extended to about 15 feet beyond the area of excavation where the contaminated soil had been collected. And then they covered that geotextile fabric, if you will, plastic fabric, with an additional 6 to 18 inches of sand and gravel fill. Unfortunately, a portion of the contaminated area was also a roadway. So they covered the roadway with crushed rock, basically to protect the soil underneath. But I think that means that the geomembrane may not have extended across the roadway. A chain link fence was then put around the covered excavation area, but excluding the roadway. So, which unfortunately means then that there was vehicle traffic on top of this excavated area where PCBs had been found. So I have a couple of technical objections to the way this was closed, but that's not really the point of my testimony. I'm just sort of walking through this so you know, have some idea of what's here, what has been done, and what may remain to be addressed in the future. So let's move on. And if I'm getting too far into the weeds, Ms. Rice, just say, oh, I've had it with hearing about contaminated site cleanup. Can you just go a little faster? That would be okay.
So let me just say, I'm going to leave it to your attorney to tell you when you need to speed up or slow down or give more or less detail.
Mhm.
And also, since we braked here, Ms. Clengen, I think you were showing other documents. Ms. Jenkins didn't refer to any of them specifically. I don't know if those are if you're offering those. I don't know. We should talk about those now.
Yes, I was trying to pull up the documents that were related to some of that testimony about the PCB contamination. And I basically, we've got exhibits
One second. I don't know, Mr. Sturbank, are you attempting to object?
No, Ms. Examiner, not object, but just you touched on a point that was a little bit of concern as we were going through. I'm wondering if it would be helpful as so that it's clear if the attorneys, after documents are shown, would formally offer them so that the parties know whether something is being offered, or that we didn't miss a flash of a document on a screen and later it's assumed that it was in.
Agreed. Yes. I had hoped that I made that clear at the beginning. Only documents that are actually testified to directly and explicitly by the witnesses are going to be considered not stricken. So I do want to have attorneys do that. So thanks for raising the point and just making it clear. And Ms. Clungeon, please go ahead.
Yes, sorry, I didn't want to interrupt Ms. Jenkins' testimony, but so her discussion of PCB contamination, we have a number of exhibits that might be relevant to that. So let's see, we've got, there is exhibit 34, I believe. There was discussion, PCB contamination at the plywood plant, the fire site that she mentioned. There is also exhibit 33, which is related to the PCB cleanup for, I believe, the transformers that were mentioned. And then 32, that's an additional assessment of PCB contamination. So we're offering 32, 33, and 34 related to the contamination on area 3. Sorry.
Okay.
Can you stop on this page? I think this is a great illustration of.
I was just going to ask, we're going to have direct testimony about any of these documents, so that'd be helpful. And when we are looking at a specific document, it'd be helpful if you would somebody would verbally state the exhibit number for the record.
So I think this was exhibit S34. Is that correct, Audrey?
This one is on here. It's not showing up on my description here, but 33.
33. So
yes.
So this does address the PCB spill cleanup that I've just walked through in a very brief manner. So I think what is super relevant here is that this report concludes the PCB concentrations remaining in the soil range from 33 parts per million to 34,000 parts per million. So this is a numerical indicator of the fact that the cleanup at this site was incomplete. And the date of this document, 1990. So this was roughly a year after the accident, the fire happened. And yeah, there's a set of 3 documents in the record that I also relied heavily on for my testimony, and they are Delta Environmental's summary of, I think they're called environmental site assessment documents number 2, environmental site assessment 2 and environmental site assessment 3. Those are exhibits S12 and S13. They provide a fairly detailed summary of all of the known contaminated sites and cleanups.
Would that also include exhibit 11? That's another one of the environmental assessments for level 1.
Yeah, the level 1 doesn't go very far. It basically says this is what we know so far. Level 2 and level 3 actually included additional sampling, so they're more informative. Although, I mean, the level 1, I'm not saying that was not a valuable document. I'm just saying I haven't really referred to it that much.
Okay.
Here. So we've just talked about, if we could go back to the figure, we've talked about the transformer T12 area, T12 area. Did I talk about the T17 area? Yes, I did. The T12 area is where there was a much more serious area of contamination that they then covered with the geomembrane. It's also where that subsequent investigation showed that there were still very high levels of PCBs remaining in soil. So just some background about PCBs. It stands for polychlorinated biphenyls. This is a family of chemicals that are highly persistent in the environment. They're also highly toxic. And so they're of grave concern, not just because they're there, but because they can travel in the groundwater. And that is a concern because if they're traveling in the groundwater, they can migrate to places where they oughtn't to be, specifically the Snoqualmie River in this case. Contaminants also, no doubt, have wound up in Borst Lake, which is at the southern portion of this figure. Yes, that, did I say that Borst Lake?
Objection,
Yes.
Madam Examiner.
Yes, please.
I don't believe any foundation has been established for the conclusion that was just offered.
And I would second that objection, Ms. Examiner. This is Jackie Carey, by the way, one of the attorneys representing appellant. And I'll be the lead attorney in addressing Ms. Jenkins' testimony.
Thank you.
Okay, well, I'd love to respond if I may.
Ms. Jenkins, 1 second. So when there are attorney objections, I need to A, clarify the nature of the objection, and B, I'm going to hear from your attorney first. I'm then going to rule on the objections, and then you can continue with your testimony. So thanks for being our first witness to be the guinea pig, and so we can all figure out the process as we go. Just to clarify, Mr. Sturbank's objection is lack of foundation, and Ms. Carey, did you have the same objection?
Yes, same objection.
Okay, so let me hear from Ms. Plungen about that, please.
And Ms.
Oh,
Examiner, I
yes.
apologize for interrupting, but it's difficult when the witness is testifying in a narrative fashion. There isn't a question that would then allow us to get an objection in advance of
Agreed.
testimony being proffered.
Agreed. And please, everyone know, Ms. Jenkins and all witnesses, please know, because we're in Zoom and we're not in the room, I can't see the attorneys waving or otherwise getting my attention. I've asked them to verbally object and interrupt witnesses in order to make their objections. So he was following instructions by interrupting you, and I apologize for that. Ms. Plungen, did you want to respond to the foundation objection?
I just want to clarify. So is it related to that PCBs can travel in groundwater, or that the PCBs have likely connected to Borst Lake? I just want to clarify.
Mr. Sturbank?
There was an opinion offered, and I believe it was not likely, it was no doubt, and then connected to Borst Lake, and there had been absolutely no evidentiary foundation laid about testing or documentation or any evidence of contamination of PCBs or otherwise in Borst Lake.
So it was the travel to Borst Lake.
Okay.
Thank you.
All right.
I would actually add to that. I agree with the no doubt statement that Mr. Sturbank just made, but add to it, right before that, there was testimony speculating about the contaminants being in the Snoqualmie River as well, PCBs specifically. And I did not hear a foundation for that opinion to the extent one was offered.
Okay.
Okay. In response to that, I believe the exact wording was they can migrate to places where they ought not to be, specifically the Snoqualmie River. So that was not saying they absolutely do, but they can. And I would say that the migration of PCBs and groundwater, the basis for that is Ms. Jenkins' expertise, understanding these chemicals and how they travel and across sites. And then also regarding Borst Lake, I mean, we don't have specifics here yet, but it's my understanding that there's a certain level of certainty that there is likely levels of contamination in Borst Lake, but that frankly, getting back to a lot of the issues that are repeat in this case, is we don't have that information. We're lacking that data. So I would say that, not to put words in my witness's mouth, but I think we're saying there's a high likelihood, but that we don't have information at this point.
Mr. Sturbank?
Briefly, I think the lawyer just admitted to the lack of foundation. There's no data, I believe, was the statement. And it is improper for a witness, expert or otherwise, to offer a conclusion about no doubt there is something is present when their lawyer admits there's no data to establish that conclusion, let alone the likelihood. There hasn't been any testimony. With due respect to Ms. Jenkins' expert qualifications, she also did not lay any evidentiary foundation for travel of PCBs, time, distance, data, studies, any scientific foundation. So all of the opinion testimony is improper, and I'd move to strike on that basis, at least unless and until some foundation is laid.
And I would second that without anything additional to add to what Mr. Sturbank just said.
Okay. I'm going to ask Ms. Jenkins and all witnesses to be aware that we need to have evidentiary support for conclusions that are offered, or there will be a lot of objections. So if to the extent that Ms. Jenkins did testify that no doubt that PCBs have traveled, that testimony could be stricken, but she is asked to, all witnesses are going to be asked to provide evidentiary support for conclusions that you offer in your testimony. And with that, I believe after all the interruption, we can get back to Ms. Jenkins' testimony.
Thank you. And I think your objections are justified if I said there's no doubt. I don't believe I said that. And if I did, I was in error. What we don't have at this site is a comprehensive groundwater. There has been no comprehensive groundwater study conducted. We do not know in a complete picture what the groundwater behavior is in the subsurface of planning areas 1, 2, and 3. That is an unknown. There have been numerous monitoring wells placed over time. Many of them were placed near areas that were of known contamination that was being remediated, or to find out whether groundwater had been contaminated by contaminants known to be in the subsurface. Unfortunately, many of those monitoring wells have been either abandoned and or removed, but there has not been an effort to fully understand the groundwater flow path or paths across the site. So if there were mobile contaminants that got to groundwater, we don't know where they would wind up, which causes me to think there is a possibility that contaminants from this site may have a pathway to reach the Snoqualmie River and or may have a pathway to reach Borst Lake. And that was the basis of my statement. So forgive me if I overstated and said no doubt, it's in there. That was not what I intended. I don't believe it's what I said. But when we're looking at how to understand contamination at a site that is being proposed for future development, I think it's incredibly important that we understand what's going on in the subsurface, because development requires digging up stuff. You can't do a building foundation without moving dirt. And because of the presence of this shallow aquifer, there is some risky business in not knowing what the groundwater is doing. Which way is it flowing? And groundwater is complicated. We have a general understanding of the geologic profile here. But we don't have an understanding of the specifics of the geology at this site that would give us a predictive understanding of where that shallow aquifer is going and which way it flows and its seasonal variation of flow. I think some people don't recognize that groundwater flow is not consistent over time. Particularly shallow aquifers are very sensitive to the amount of rainfall that's happening, to if they are influenced by nearby flowing surface water, though the connection there may also impact stormwater. And we simply don't know those variables for this particular site.
Ms. Examiner, I have an objection. Again, apologies for the interruption. So we're hearing testimony right now on a shallow aquifer, but again, I've heard no basis for any sort of opinion on a shallow aquifer or identification of a shallow aquifer. So, you know, to the extent that Ms. Jenkins is testifying about this and giving an opinion on that aquifer, she needs to lay a foundation for that.
So it's the presence, you're objecting to the fact that there's no foundation laid for the presence of a shallow aquifer?
That's correct. I'm completely lost what the opinion is that's being offered right now because we haven't heard the foundation established.
Okay, and Ms. Clungeon?
And
Ms. Examiner, excuse
one
me if I may, the city joins in the objection, and I would say the objection is not just to the absence of foundation for the existence of the aquifer, but to the extent that there is one, any definition of its aerial extent or depth.
All right, so Ms. Clungeon?
Pam, regarding your statements for the aquifer, could you help point me to the basis for that, or where we could point to a document to show about the aquifers on the site?
Yes, but I think I'm going to have to do a little bit of review. I think these comments originated in my comments on the draft EIS, and I will have to go back through to specifically note which documents. I mean, because when we're talking about the wells that were the groundwater monitoring wells that were put in place for determining groundwater contamination around some of these contaminated sites and then removed, we only have a tiny bit of data. And so I will need to go back and specifically find those quotations. Believe me, I did not make this up. But where if this is where it's hard for me when it's on screen rather than with my paper documents. It's a little bit difficult to locate the information as quickly as I would like to. So if I may have your permission to revisit this when I've had a chance to go back to my source documents to bring up those citations, I would like to do that.
1 second, Ms. Clungeon. Are you gonna offer something?
I was going to point to a couple of spots, even within the draft EIS, where they're talking about critical aquifers and recharge areas, and we have some maps as well. I'm just trying to find the right spot to bring up and share my screen here. So, but yes, maybe we can revisit that while I try and look for that. Second.
I think my most important point is this is 260 some acres of property. Even with the number of groundwater monitoring wells that may still be operable on this site, unless they have been sampled on a quarterly basis for at least 2 years, we cannot understand groundwater behavior here. Ecology's rule of thumb, it is actually a requirement for understanding groundwater behavior for landfills, which are also can be contaminated sites. They require at least 8 quarters of sampling of the groundwater. I have not found in the literature any sort of systematic sampling of the existing groundwater wells. What I did see was wells that were put in place and sampled once, such as in the most recent investigation of planning area number 1. That gives us data for one point in time, but it can't possibly give us any information regarding seasonal flow variations. And seasonal flow variations also impact contaminant concentrations. So not having very much data regarding the groundwater makes it extremely difficult to state anything with certainty. We don't know. I mean, the Farallon investigation posited that the general groundwater flow direction in planning area 1, I'm not sure if I remember exactly. I think they said it was toward the southwest. I'd have to find that in my notes, but that was based, I don't even know how they would make any sort of conclusion from a one point in time sampling of the 8 or so monitoring wells that they put in place in 2020 or 2021 for a report for which we have no actual data. So it's hard for me to sort of fight against an objection that says, what is your information, when there's so very little information in the record regarding the subsurface, regarding the groundwater that underlies this site. So I'm saying this is a could be, and without more investigation specifically of groundwater behavior here, nobody can answer the questions definitively. So thanks for your objection. I have the same objections in a way. It's like, we don't know. We don't know.
And I would also,
Were you going to continue with the objection?
What topic?
Ms. Examiner,
Yeah.
I think in light of that testimony that we just heard, the city would move to strike any opinions to the extent they were stated about the existence of groundwater contamination. I think the witness just said there's no information from which one could conclude one way or the other.
That's not what I said. I'm sorry. I talked about groundwater behavior. There has been proven groundwater contamination in several locations at this site, but proving the existence of contamination is quite a different exercise than attempting to understand the movement of groundwater in the subsurface. And that is my point. That is what groundwater behavior is how is that groundwater moving? Because it's the movement that carries contamination.
Jumping in, Mr. Sturbank.
I think where we started on the testimony was that opinions were expressed about the possibility, likelihood, or conclusion. The words "no doubt" were used about the migration of contaminants in groundwater to the Snoqualmie River and Bourse Lake. And the witness has just acknowledged that she shares the objection and that the lack of information, in her view, quote, and I was trying to take verbatim notes here, makes it extremely difficult to state anything with certainty. We don't know, unquote. In light of that, any opinions about groundwater migration of contamination should be stricken in the absence of any evidentiary foundation. So I guess I'm renewing the objection made previously. It doesn't sound to me that, or me rephrase that. It sounded to me that the testimony just buttressed the objections rather than overcame them.
And I second that, Ms. Examiner, and with nothing to add.
Okay, so what we're back in the same place we were the first time, that we need to have evidence to support conclusions, and that I guess the witnesses should be careful to state, to posit theories in the context of there being theories and not as opinions. It'll also help if evidence in the record, or if there is evidence in the record, that if it's cited during testimony, that would help.
We will. Can I just respond to some of that? So regarding the no doubt, we've already handled that. She said that, you know, it was not no doubt, it was likelihood. So also getting back to Ms. Jenkins is providing an overview of what we know of contamination at the site, and frankly, some bits of what we don't know, which is relevant to a lot of the issues that we're raising in the appeal. The fact that we can't prove that you don't have, that's not really the point here. I would also say regarding the shallow aquifer, I mean, I'm looking at the ground appendix B to the DEIS, the applicant's own documents. This is on page, let's see, 2.113, where it says a shallow aquifer is present beneath the site. Deeper aquifer is formed with sand. So we can get back to the aquifer later, but I just wanted to establish that there's a basis for a shallow aquifer on the site provided by the applicant. And then also we could get to additional documents later establishing the extent of contamination on this site. So I think we'll get there. I would argue some of these objections are premature, and I'd ask that we be allowed to proceed.
Ms. Curry?
And Ms. Examiner, just for the record, Ms. Kludgen, what exhibit are we looking at right now?
Right now, we're looking at it is Appendix B to the draft EIS, which I believe that's been offered by all of us as a different exhibit number. But
so I believe it's Exhibit 2 in
yes,
Scan's exhibit. Okay. So Ms. Examiner, just a follow-up to all of this, I think some of the trouble that we are having is there is ongoing narrative testimony occurring. And I know that happens, especially in this Zoom format, so it's a struggle. But there hasn't been a very clear pattern of question and answer on direct with exhibits being offered for us to track what it is that Ms. Jenkins is actually testifying about. And in the interest of trying to keep this efficient and, you know, target our objections, I think that would be a helpful way to proceed, is to have a little bit more of that question and answer if possible from Ms. Kludgen, just to direct our objections as well.
Kludgen, are you able to do some direct questioning?
yes, and we will get to more of the direct questioning when right now the narrative form is it's related to an overview of the contamination of the site. So to the extent that I can, I will. But right now we're kind of setting the stage and just getting up to speed on what the current condition, what the conditions are that we know. So.
Okay, and what stage are we in the context setting narrative testimony? How close are we? Like how far along are we in that?
I don't have a sense for that. Ms. Jenkins?
I would say we're about halfway through, just walking through the known areas of contamination on the site.
Yeah. Okay.
Mr. Sturbank?
Thank you, Examiner Rice. So if the purpose of the narrative testimony is to describe known contamination, then perhaps the witness can limit her testimony to known contamination and not offer speculative opinions about migration, particularly when the narrative testimony is is establishing a lack of foundation for any opinions like that.
Let's,
I mean, it sounds like the goal is factual testimony about background. So if the testimony is limited to that, then probably Ms. Query and I can stay out of the way. It's when the opinions are being offered without evidentiary foundation that we need to jump in.
and she nods her head in
That's,
agreement.
yeah, that's my concern too, is that we're hearing far beyond just factual background at this point. So if that's the intent of this, it may be appropriate to limit it to that for right now until we get into actual question and answer.
So it's not my typical practice to tell people how they have to present their evidence, but it might facilitate things if it was possible to separate a factual context statement from the opinions part of the testimony. Ms. Jenkins, is that something that you could do fairly comfortably, separate factual known information from opinion statements?
Yes.
Okay. Let's and Ms. Jenkins, can you give me an estimate in minutes how much longer you think your context statement, your factual background would take?
I can go more quickly, maybe 15 minutes.
Let's do, so I was going to suggest that we complete the factual context setting statement and then we break for lunch. That's what I was going to suggest. So if we can do that in 15 minutes or half an hour, that would be great. So with that, all of that, I would like to have Ms. Jenkins continue with her context setting testimony, and we'll have fewer objections if you reserve your opinions for after the fact context setting statement, it sounds like.
Will do. Thank you. Audrey, can we go back to the figure that was up before?
The map?
Showing the map, yeah.
Yes. So that was 144, right? This?
There it is. Yes.
Okay, great.
Okay. So I talked about the transformer area. Also in the same area, if you look toward the southern end, actually it's in that same outline, I think it was a building outline where the transformers were just outside. There's something that's an arrow pointing to the press pit. So this, I'm guessing a little bit that because I don't know the details of this particular plywood operation, but or plywood manufacturing operation, but I presume that they used a heat press method for the gluing of the plywood, and that happened in a press pit. That is a guess on my part. But after this building, the plywood plant burned down, they did, whoever came in and did some remedial investigation found petroleum hydrocarbons in soil here and in water. So there was apparently an excavation approximately 4 or 5 feet deep in this area. And the excavation extended, it was 15 feet wide and about 60 feet long. The record shows, the report here shows that approximately 30,000 gallons of water were removed from the press pit and soil excavation, and then run through an oil water separator, which I thought was curious because oil water separators don't do a fine separation of oil and water. When there's a lot of oil, then they are effective in separating most of that oil from the water. So this was a really oily mess. And the report did not really opine as to what the source of the oil was here.
Just to clarify, which report are you referencing, just so that I can bring it up and offer it as evidence?
This actually was this, I believe, was in the draft EIS in the discussion of, it was in Farallon's discussion of the previous investigations and remediation of the site. So I think that is Appendix D, if I recall.
Okay,
And for the record, the DEIS will be in the record at Exhibit C2, City 2.
Okay, thank you.
then I just want to bring it up just to lay the foundation. So which exhibit did you say that was for the DEIS? Pam?
I believe it was Appendix D
Appendix
in
D.
the DEIS,
Okay,
unless I have it. Yes.
okay, all right. So it is this. All right, and it was regarding 30,000 gallons. Oil.
That were removed from the press pit
Okay,
soil excavation.
okay,
So what's not told in this discussion was, there we go. So they excavated until they got to an acceptable level of contamination in the remaining soil.
Can I just ask a operational question? Can the folks hear the construction noise outside my residence right now? No, good.
No.
I just wanted to know if I needed to keep my microphone muted. Thank you.
And let me just point out that right there where that hand is, it says the press pit is in close proximity, less than 60 feet to the transformer T12 area. And the flow direction of the uppermost groundwater is expected to be to the south, away from planning area 1. So even this consultant's use of this word expected to be indicates that there may not be, there I'm opining again. Let me just point that out for the record, that I'm not the only one who has a question mark about groundwater behavior. To the south, by the way, would be in the direction of Borst Lake. So moving on from the press pit, there was also a diesel underground storage tank located near the corner of this building outline at the southern end of the plywood plant. That tank was, according to the record, was removed in 1989 after the plant burned. Approximately 500 cubic yards of soil were removed from both. This was combined for the press pit and the diesel underground storage tank area, and that soil was disposed of off-site. What was notable about a water sample collected from the underground storage tank excavation was that a PCB, Aerochlor number 1260, was present at a level that exceeds our current MOCA method A cleanup level. So it wasn't just oil here, but also PCB. There was no information given about the potential or possible source of that PCB contaminant. So let's move now, because I'm sorry if I'm getting too far into the weeds, but let's move over now into the area. It's called the Moorbark area, right there, southwest from the plywood plant. This Moorbark area is where the debarking and chipping equipment was located. And so as the logs came in, they were debarked and chipped up, and the equipment apparently that was in use up until the 1970s, according to this, again, according to the information in Appendix D of the draft EIS, the lubrication of that equipment was by manually pouring oil directly onto the drive chains of this equipment. These machines also were reported to leak hydraulic fluid. So in 1991, when an excavation was done here, there was sampling that showed diesel and oil range hydrocarbons were detected in both soil and groundwater samples. Excuse me. And in 1998, so 7 years later, there was a remedial action where 110 tons of asphalt and concrete from the pad that was underneath that chipping and debarking equipment was removed. And nearly 1,400 tons of petroleum contaminated soil were also excavated and removed. That soil was disposed of at another Weyerhaeuser site, which they call the Weyerhaeuser Headquarters Landfill in Castle Rock, Washington. Subsequently, in 2005 and 2006, there were additional excavations, and an additional 1,500 cubic yards of petroleum contaminated soil was excavated from the vicinity of this Moorbark area. And that soil was treated in biocells, which I mentioned earlier, that were located in a vacant building on the mill site. The treated soil was reported to have been returned to the excavation area and compacted in place. Other areas of concern within Planning Area 3 that are not mentioned in the draft EIS are the boiler ash fill area, which is to the west of the Moorbark area, yeah, right in there, where boiler ash was apparently, well, where boiler ash was known to have been buried. And that is according to the Delta Environmental Site Assessment reports also cover all of these areas that I am talking about. And those documents are in the exhibit list. I apologize for not having these numbers right at hand. There we go. So,
Exhibit 12 and 13.
yes, S12 and S13 are the level 2 and level 3 environmental site assessments conducted by Delta Environmental, and which also presumably may have served as some of the source material that was included in Appendix D of the draft EIS. Let me just state that there are a number of overview documents in the record that discuss these various sites that I'm talking about.
And just to clarify, so the Delta reports discuss the boiler ash, and does the FEIS or DEIS discuss the boiler ash?
Not to my recollection.
Okay, but the Delta reports do?
Yes.
Okay.
So if we could go back to the little diagram, that would be helpful for me. So the boiler ash fill area is of note because of the nature of boiler ash. Typically at sawmills, the boilers were fed hog fuel, which is wood chips. Because it was cheap, it was at hand, it was essentially a resource that came from the trees that had been harvested, but the pieces that were not going to be part of plywood manufacture here, or of even non-plywood straight lumber. So in the combustion of woody materials, depending on a whole bunch of, depending on the combustion environment, it's very common for dioxins and furans to wind up in the boiler ash. And so a boiler ash fill area is of concern when doing an environmental site assessment or a contaminated site assessment because of the nature of dioxins and furans. They are highly persistent chemicals in the environment. They just don't break down. They're also highly toxic. And if they wind up in the food chain, can significantly impair certain functions of the animal or human being that happens to ingest them. So
I'm
Mrs.
gonna.
Examiner,
I'm gonna note
I have
objection.
an objection. Just again, it seems like we're going down a potential opinion path with some of this testimony, and I have not heard a clear foundation laid by Ms. Jenkins for her experience in mills, or specifically this mill and the activities that went on in terms of the generation of boiler ash or how that process works. And again, just trying to establish that she does have the experience to be testifying and offering expert opinions on these issues.
Okay. Let's have some testimony to either identify, yes, we have foundation, or no, we don't have foundation for those opinions.
I would just, this is expert testimony, and Ms. Jenkins is relying on her expertise in this area. I think she has sufficiently established that she has worked on a number of contamination issues and various contaminated sites. And she's also relying a lot on a lot of the documents that we're providing. That's a basis for the activities, the contamination that's generated. And then I think she's perfectly qualified to provide her opinion about those toxics and the impacts that it could have.
Let me ask Miss Jenkins. I did look at your CV, but I don't remember it now. Can you refresh my recollection? Have you worked on sawmills or boiler ash in previous matters? Or is this just knowledge you have from your other work in the field?
Hold on just a second. Let me sort of review some of my past experiences mentally. I have not personally conducted an environmental site investigation on a sawmill. I am familiar with several reports that are included in the Department of Ecology's database of contaminated sites. And so I am familiar with those reports of similar sawmills that have similar types of processes and equipment, such as boilers that burn wood chips. That's a pretty common thing. In the first 5 years of my career, I was part of their air quality department at the Department of Ecology, and was a permit issuer for large combustion sources. So I do have familiarity with combustion processes and with some of the chemistry involved with what is potentially put into the atmosphere if the gases and particulates from combustion processes are not properly controlled. So I do have foundation. It doesn't take an expert to find out what the hazards of boiler ash are. I think a simple Google search would probably inform you that boiler ash often, if not always, I don't know because I haven't done this Google search, but I would guess that that search would show that dioxins and furans are one of the potential hazards of boiler ash.
what I'd like to do, Ms. Correa, is rather than pursue this objection, I'm going to let the parties inquire during cross-examination about any other concerns they have regarding Ms. Jenkins' qualifications.
That makes sense. Thank you, Ms. Examiner. I think just to kind of close on that note, again, we're supposed to be in a portion right now where we're establishing a factual background, and we're getting a lot of speculation and opinions about what those facts mean. So again, just in the interest of trying to not have to continue to delay with objections in this portion of the testimony, trying to keep it to the facts, we'll keep our objections limited.
Okay.
So one fact is that this area has not been remediated.
Okay.
That is a concern.
All right. And-
Also not mentioned in the draft EIS, but is clearly mentioned in earlier reports regarding this site. Another area of concern is the vehicle wash pad. And that is,
Pam, just before we get into the vehicle wash pad, I just sort of want to follow up, just a couple of follow-up questions, somewhat related to the objections, but okay. So does your experience provide you with a basis for expressing opinions on boilers that you have been expressing?
I would talk about, I think my experience, I'm not a boiler expert, but I would consider myself an expert in air quality.
Okay.
That means emissions from boilers, I am quite familiar with.
Okay. And your testimony, you were talking about, what was it, dioxins and furans?
Furans, yes.
Okay. Are there other projects that you've worked with or worked on that dealt with similar contaminants?
Yes.
Okay. All right. That's all. Okay, continue.
Thank you.
Okay, and you were, what was the next area? Was it the tank?
So we're still in planning area 2 and the boiler ash fill area.
Planning
And
area
if you go south from there, there's a vehicle wash pad. And to the south, to the east, that 50,000 gallon fuel oil above ground storage tank. And dip areas number 1 and 2, dip tank areas 1 and 2, which are further, there's number 2, and then go further north to dip tank area 1. These areas of concern are not mentioned in the draft EIS, but they are reported by the Delta environmental site assessment documents that were previously cited, S12 and S13. And as I recall from the Delta reports, the boiler ash area was fenced off, but no removal activity had taken place. And I think the date of those documents was roughly, the level 2 was done in 2004 and the level 3 investigation followed in 2011. So I just wanted to sort of indicate that there are more contaminated sites that have been discussed in earlier documents than were included in the draft EIS.
And I just want to be clear, you said level 3 in 2011, I have 2004 here, so I just want to make sure there isn't another Delta report that.
The 2004, 2000, the level 2 was done in the earlier year. So the level 2004 report.
Mm-hmm.
Oh, that says level 3. What am I saying here? There was a supplemental environmental site assessment done in 2011. I'm sorry for the misinformation.
So hold on. Got a supplemental environmental assessment. I've got that for 2005. That's exhibit 14.
This was just for one area. I believe there is more than one supplemental environmental site assessment document.
That. And I just want to make sure we pull it up, have the right one.
I don't, this is the report, but again, given a bit of time over lunch, I can probably find the correct citation.
Okay, all right. We'll come back to that.
So Ms. Jenkins, did we complete your background of contaminated areas on the overall site?
Yes, and let me just provide one summary statement and then we can break for lunch. I think what's been pointed out here is that there are many distinct areas of known contamination on the site, some of which have had some remedial attention. And I say remedial attention because in some cases, the remediation appears to have been complete. In other words, the remaining soil, if it was an excavation, that the contaminants in soil were then below the standards at the time, below the contaminant standards, or what we would now call a MOTCA method A level, if it was being done today. Some of the remedial efforts were admitted to be incomplete in the records. For example, the boiler ashville area, because of the nature of the contaminants and some uncertainties, perhaps I'm conjecturing here, for whatever the reasons were, they did not complete a cleanup of the site. They chose to fence it off. The issues here are a migration of cleanup standards and the fact that getting one's arms around the number and complexity of contaminated areas here is not a simple procedure. My point is there is a need for a comprehensive understanding of each of these contaminated areas and for a well thought out strategic remedial action plan developed before redevelopment of this site can be considered safe.
Okay. All right. Thank you for the context statement, Ms. Jenkins. It's 12:54, 12:55. I propose we break for lunch. I don't know what time interval to choose. Should we try to be aggressive and come back at 1:30, or should we take more time? Either 1:45.
I would ask that we take more time. 1:45.
Mr. Survey
That's what I was going to say as well. Thank you.
splits the baby between an hour and 30 minutes. So, Ms. Correa?
That works for me as well.
Okay, and please tell me again, because I just heard your name for today for the first time. How to say your name again?
Yes. So it's Jackie Carey is the
Carey.
last name. Yeah.
Carey.
And I apologize in advance. I didn't get a chance to introduce myself clearly before this, but I'm also dealing with a really terrible cold in my throat. So if you can't understand me, please speak up and let me know.
Great. All right, let's go. We'll break now. It's 12:55. We're coming back at 1:45 and we will pick up there with appellant's first witness. Thank you.
We dive into the rest of this testimony to understand the order of testifying experts, fact witnesses, everything that we're anticipating for this afternoon and tomorrow, and also discuss a couple of scheduling concerns that we have with our availability on that regard. So I was hoping to do that so that we can coordinate with our witnesses before we continue on with the testimony.
That makes sense.
Although in that regard, it might be useful to have the ruling on the motion regarding the flooding witness.
Sure. All right, then Ms. Jenkins, please bear with us. We're going to deal with some other business. I did take the opportunity during the lunch break to review the searchable documents, which confirmed my earlier assessment that the appeal letter does not explicitly address flooding, sewer, or stormwater as issues on appeal. The words are mentioned in passing, but no explicit error is assigned with regard to any of those three issues. And based on the applicant's motion with the city's joinder, I will be excluding those issues. They are not perfected in the appeal. So with regard to the impact to witnesses, the one witness whose sole area of testimony identified was flooding is Mr. Chase Barton.
Correct.
And I believe with flooding excluded, we will not be requiring his testimony. Several other witnesses also have listed as their areas of testimony, including stormwater, sewer, or flooding, floodplain issues. So I will at this time let folks know that I will not be hearing testimony on those issues because they are effectively excluded from the appeal. Specifically with regard to the other witnesses whose testimony was questioned, I did again review the appellant's offering of Mr. Dordowski's testimony, and in review of the items for which his testimony appears to be offered, the only one that is not that seems to be potentially relevant is land use, because growth management, comprehensive plan are not issues in this appeal. I don't know what policy was intended to refer to, and I also don't understand what we would hear about development regulations that would be relevant to the FEIS. So I was not planning to strike Mr. Dordowski's testimony, but I will obviously let folks know that I expect objections during Mr. Dordowski's testimony to the effect that it strays outside into any of these issues that are effectively excluded because they were either dismissed in the appeal or not perfected in the filed appeal. I am not going to exclude testimony from Mr. Jack Mr. Hill, Mr. Erland, or Miss Linney, except to the extent that it addresses any of these issues that have been dismissed in the pre-hearing ruling or in this ruling now. Again, we've been advised that we will be expecting objections, and I'm sure the parties will be watching for testimony that strays outside the issues that are perfected in the appeal. With regard to the exhibits, I'm not sure I made it clear. I did already strike 20. I am expressly admitting 44. With regard to the others that were objected to, which are 19, 25, 38, 41 through 43, and 45 through 51, I have noted applicants' motion, and I think city's joinder in the motion, to strike any exhibits that are not referenced in testimony and therefore shown to be relevant based on the appeal, and also portions of exhibits that address issues that are outside the scope that have been expressly dismissed or excluded. Those portions of those documents are not intended to be admitted. So that's going to be messy, and there we have it. So I am expecting additional, I will be asking the parties to object to the documents at the time that the offering party raises them. Mr. Sturbank has a question.
Thank you, Ms. Examiner. So S41 through 43 relates solely to flooding.
Thank you. I knew that I was missing one. Thank you.
And so those, I think you listed those in what you just went through, but those seem appropriate for a blanket treatment, given your ruling on the issue.
They are listed. Yes, I am going to strike those three as well. Thank you. Other questions, clarifications? No. Okay, then let's turn to the next item of business. Again, begging Ms. Jenkins' patience to address scheduling for this afternoon and tomorrow, especially. Questions, were there specific questions, or are we looking for Ms. Clungeon to give us a heads up as to where her case is headed today?
Ms. Examiner, we did have some specific requests that the appellants identify the order of their witnesses so that we can get a sense of when our witnesses will need to listen or testify. And then we also do have some availability concerns with regard to our contamination witnesses and Ms. Perez. So would ask that Mr. Jack testify tomorrow.
Let's check in with Ms. Klungen and address these requests first and then see if there are others. Can you help us with the order of witnesses at this point?
Yes, it's been a little in flux till recently, but yeah. So for the rest, do you want just the order or when I expect that it will occur?
Let's go order and then let's identify who is most likely to be heard today and tomorrow.
Okay. All right. So with Barton gone, after Jenkins this afternoon, I was going to maybe have a couple of our lay witnesses testify. So the order was going to be Lacey Linney. And then after that, potentially Mr. Russell and Erland.
In that order, Jenkins, Linney, Russell, Erland.
Assuming that they are available. Yeah, yes. And then after that, which I anticipated probably tomorrow, but is Norris for transportation, followed by Hill. And then in the afternoon tomorrow, Sarah Cook, followed by Richard Jack, and then Brian Derdowski.
All right. We just had a request from applicants. I believe that Mr. Jack's definitely testify tomorrow. That can the order be switched so that Mr. Jack speaks first, considering that we don't know for sure when we're even going to get to the witnesses listed for tomorrow.
Right. One moment. I would just want to check. I think he has an availability issue, so that's why he was tomorrow afternoon. But I just want to confirm that. Actually, no, I've got he's available all day tomorrow.
Okay.
We could potentially move him up.
Does that work for the parties who had a concern if we put Jack first?
Thank you. Yes, that does work, and appreciate the flexibility
Yes,
for
thank
the
you.
appellants. I also just wanted to check Dr. Cook in the witness and exhibit list. Her subjects of testimony are identified as wetlands. It doesn't say that she is going to be talking on contamination, so I just wanted to double check and make sure that she's not speaking on contamination. Otherwise, we would have the same request of her that she be early in the day, but given the witness list, I'm reasonably confident that that won't be a subject of her testimony.
Ms. Klungen, any comment?
Hold on 1 second. I just want to see if we identified. I believe Ms. Cook will briefly touch on contamination to the extent that it relates to concerns about wetlands and hydrology of the site. Not as an expert, but she does have degrees in soils and wetlands and things like that. And given the contamination on the site, that topic will come up in that context.
Thank you. In that case, we would request that she follow Mr. Jack if possible.
Is that possible, Ms. Klungen?
Or broadly that she testified tomorrow at some point.
So be third at the latest.
Yes, I think we can accommodate that.
Okay.
Thank you.
And those were the only two, Jack and Cook, that you had concerns about for tomorrow, Ms. Kaler?
Yes, for tomorrow.
Just check. Mr. Sturbank has his hand raised.
Thank you. So does that mean that I assume Mr. Norris and Mr. Hill will be afternoon tomorrow?
I'm guessing that's true, because we'll have at least a full morning testimony. for at least
Okay.
one, if not both of those witnesses. At the speed we're going.
That was my assumption as well, but I wanted to clarify so I can let our witnesses know.
I just want to verify.
Sure.
I think Mr. Hill on Tuesday is really only available in the morning. So I think we might still try and have Mr. Hill speak earlier.
So perhaps Jack, Hill, Cook, Norris, Derdowski.
Sorry, what was that?
Jack, Hill, Cook, Norris, Derdowski. Will that
Yes.
work?
I think that should work.
All right. Any other order or scheduling concerns that we need to address or that we should be thinking forward about now at this time before we continue with testimony?
We will have some limited witness unavailability when it comes our turn, but I don't think that needs to be addressed at this point, and it may just never come up.
Okay, thank you. All right, it looks like the answer is no, but thanks very much. I'm glad we did that. That's very effective. Thank you for being proactive. Let's continue with the testimony of Ms. Jenkins. We interrupted our testimony after the conclusion of what she described as a context factual overview, and we are returning now. I will remind Ms. Jenkins, you are under oath to tell the truth. And Ms. Klungen, please go ahead.
Okay, thank you very much. Okay. Ms. Jenkins, I believe you're muted. Okay. Okay, so let's see here. So let's just go through. You submitted comments on the draft EIS, correct?
Yes.
Okay, as well as the, and then, let's see here.
I think I submitted comments as well in the final.
Okay. All right, so let's go through those. Can you run us through your conclusions based on your review of the draft EIS and FEIS?
I think in terms of putting the environmental health of this large site into a SEPA context, we have to recognize that there have been several past contaminated site investigations, but there has never been a comprehensive contaminated site investigation for the entire site. Distinct sites like the ones we just walked through briefly, I was hoping it would be brief, in planning areas 2 and 3, those were directed at known areas of contamination based primarily on either big events like the plywood plant fire or the memory of former Snoqualmie Mill employees. But that isn't necessarily a comprehensive net, if you will, for basing a comprehensive investigation of groundwater and soil contamination that are residual at that site from the plywood mill's operations. So that leaves a gap of uncertainty, which is, I think, makes this site risky for development. So what I have noticed, this is what I have noticed at other old industrial sites that have been redeveloped, is that there is a phase of site investigation and cleanups that occurs before any development actually begins at the site. And that makes sense from the point of view of protecting construction workers, as I mentioned before, but also in terms of discovering any sort of contamination that may lead to underground contaminants that are still in the ground and may be off-gassing, which could impact future residents on a site or future employees at commercial or industrial facilities. So there's very significant safety consequences that go along with performing, or the need for performing a comprehensive investigation of the site for contamination. That has not been done in any of the planning areas on this Snoqualmie Mill property. There have been discrete contamination investigations at areas of known or suspected contaminants, which we've already walked through. But there had been no investigation whatsoever within Planning Area 1 at the time the draft EIS was written. Farallon Consultants did a very small investigation after the draft EIS was prepared, and a brief summary of that investigation was included in the final EIS. So I want to say hooray that they responded to comments from the draft EIS, but in no way was that investigation complete enough in any regard to be sufficient to describe, to ensure that development in Planning Area 1 would be safe for future uses. Now, why do I say that? Let me just explain what they did. They put in 10 test pits. A test pit is simply digging in the ground with a backhoe typically, and digging out a trench that increases in depth so that the investigator can go in and observe the soil as the excavation gets deeper and pull soil samples from any area that looks like it looks, or using a device for sort of quick measurement of volatile air contaminants. They can, if something is essentially off-gassing from the soil, that would indicate a place to grab a soil sample. So it gives a visual indication as well as this kind of an indicator of potential soil contamination, so that these soil samples can be collected, sent to the laboratory, and a very precise analysis conducted. So Farallon put in 10 test pits in a 100-acre site. Now, I just want you to think about this for a moment. That would mean one test pit representing about 10 acres. And I want to say that from simply a statistical point of view, the probability of finding contamination in an area that size with such a few set of test pits is practically zero. I think I wrote in my comments about a site that I am familiar with. It's also a redevelopment site. It actually had an old landfill on it. The developers wanted to put in a residential development. They started off with 64 test pits, and then did another 20 or so, followed by about another 15. So they wound up with a total of about 90 test pits in all, and on the order of 60 soil samples. I don't remember the exact numbers, but during excavation, in the initial excavation of this site, long before houses were initiated here, they were basically just regrading the site for an optimum neighborhood. They found an area where buried waste was found from 10 to 60 feet deep. And that had been in an area where they suspected no contamination, no buried waste at all. So even with 94 total test pits, and this was on a parcel of 17 acres, 94 test pits, 17 acres, and they still missed a substantial occurrence of buried waste. So the comparison there, I believe, is stark. We know very little about planning area 1 at this point. What we do know, and which the Farallon investigation also mentioned, is they found a whole lot of wood waste that was used as fill. That sounds benign on the surface, but I'm here to say wood waste is not benign, particularly in an area where shallow groundwater is in contact with that wood waste. According to Farallon's report, they found wood waste in their test pits from 2 to 16 feet deep. In another report that's quoted in the draft EIS, actually it may have been in one of the Delta ESA reports. They said that the wood waste was as deep as 20 feet in some places. So this fill was designed to raise the level of the lowlands in the planning 1 area. So there's a couple issues with that. One is from the point of view of construction, that wood waste is an unsuitable structural material because as it decomposes, it has it has insufficient structural strength for building foundations and roadways. So first of all, it would be extremely important for a future development to be fully aware of the extent of that, the lateral extent of that wood waste fill, because that material will most likely need to be removed before development.
I have an objection.
An objection again, we have not heard any foundation for Ms. Jenkins' testimony about the structural foundation abilities of wood waste. I'm not clear on what her expertise is in that area to substantiate her opinion on that issue.
Okay. Ms. Clengen.
I would say that some of these issues can be addressed on cross. If you want to ask Ms. Jenkins about those issues, but apart from that,
I think I do want to, again, remind Ms. Jenkins that parties are looking to make sure your testimony, your expert opinion is given in matters upon which you can demonstrate expertise. I do also want to defer as much of the objection regarding a foundation as we can to cross-examination in order to complete the testimony. So I'll note the objection and I'm going to ask her to continue.
Thank you, Ms. Examiner. If I have future objections on this, I also want to continue things along efficiently. Would it be most appropriate for me to just raise the objection, state foundation, and we can keep that documented in the record? I just want to make sure we're documenting this as they come up.
I do feel like that's the best way of handling it.
Okay, thank you.
Thank you. Ms.
Okay.
Jenkins, please go ahead.
Ms. Jenkins, could you provide a basis for your opinion about building on wood waste?
What I have seen in reports I've read about the redevelopment of other sawmills is that the wood waste, where it was found buried in the subsurface, was removed before redevelopment occurred in that area.
Okay, and again, I'm going to ask you to give us information that is squarely within your expertise. And if you're going to give us relevant information that is steps outside your expertise to acknowledge that, like you just have, how you've read that in other reports. And then I'm going to ask the other parties to just quickly, if they have objections, to note foundation objections, and then allow us to proceed with testimony. And then if they have concerns, they can go forward with that in cross-examination.
If I can also cite exhibits, if you would, or cite reports that I presume would need to be submitted as exhibits. Specifically, The Cashmere Mill site in Cashmere is a site that is undergoing redevelopment. And they also had used wood waste as fill. And the Port Gamble Warehouser Mill, actually it wasn't warehouse, I'm sorry, it was, anyway, the Port Gamble Mill site, very large up on the Kitsap Peninsula, is another one where they found buried wood waste.
For your information, the Cashmere Mill site assessment is in the record already. It
Excellent.
was submitted by Wayne Russell. Actually, it's the site characterization dated March 2013, and it's in the record.
Okay,
Just
there
so
are
you know.
subsequent reports on that, but that I think probably the 2013 report does discuss the discovery of wood waste on that site.
And just returning to that, could you elaborate on the issues with wood waste as a fill on a site?
And Ms. Examiner, if I may object just to this line of questioning in general, I was trying to see if there was a foundation to begin with, but this is not an issue that was raised in the appeal either. The structural integrity of wood waste versus contamination issues that they've raised, they're two separate issues. And so we're talking about something that was not raised in the appeal.
Substance of the fill on a contaminated site is related to the issues we raised in the appeal.
Well, it sounds like we're moving into testimony on whether it would have to be removed as a structural issue, and that is distinct from contamination issues and investigation and cleanup.
What I'd like to do is I'd like for Ms. Jenkins to present her testimony based on her expertise. And then if the parties have concerns about the level of her expertise, they can question her on cross-examination. That's how I think I'd like to proceed. She's presenting information which she believes is based on her experience and expertise. And if you're unsatisfied with her experience and expertise, I think you can develop that during cross-examination.
Absolutely. And we will do that and keep our foundational objections limited that way. Just to preserve the issue for the record, my current objection to this is actually that this issue of structural integrity of the wood waste is not an issue that was raised in the appeal. So foundation or not, her testimony on this issue should not be permitted as part of the appeal.
Mr. Sturbank.
The city would join in that objection and just note in addition that the authorities I cited during argument earlier this morning on application of ER 702 and the FEIS standard holds that in order for the expert testimony to be admissible, there must be an adequate foundation laid. That's a key part of the ER 702 analysis. So again, understanding how the examiner would like to proceed, just noting that for the record.
So the issue of wood waste being used as structural fill is obviously not stated anywhere in the appeal letter. So maybe there could be some testimony explaining why Ms. Jenkins thinks it's relevant, or we could let it go, one or the other.
There are other issues with wood waste that I would like to address.
Yes, okay, so going back to my question, Ms. Jenkins, related to wood waste, are there any issues with using wood waste as a fill on the site?
Yes.
Okay, and what are those?
We know that when wood waste decomposes, it off-gases methane. Methane is a chemical that is flammable and also functions as an asphyxiant, which means that it replaces oxygen when you breathe it in. And so it is possible in a high methane environment to actually suffocate. So for example, at landfills, like a municipal waste landfill, which has received organic matter like garbage, which also off-gases methane as it decomposes, there are required controls, methane controls, to make sure that that gas is emitted from the landfill far above the breathing zone, so methane vents. At the Midway landfill, there was a huge amount of methane there, and you may have noticed if you drive up and down I-5 that often those vents, they probably don't flare as much now, but in the early days, those vents were on fire. The methane was actually being burnt. So, and if there are buildings located in the vicinity of buried organic matter, and that organic matter is decomposing, those buildings often are required by the municipal entity or county entity with jurisdiction that those buildings have methane controls so that methane will not enter those buildings, both to reduce the risk of fire and to reduce the risk of asphyxiation if the methane should get to a high concentration. So I have mentioned before, and there was a citation noted about the presence of a shallow aquifer at this site. I believe that the Farallon investigation also noted that there was groundwater. Well, they put monitoring wells in planning area 1. Unfortunately, we don't have any of the actual data from the construction of those monitoring wells, nor any of the actual data from their sampling in these 10 test pits. I don't know why, but the report was, we were provided a summary in the final EIS, but it was not a formal report in the sense that the data tables as they are sent from the laboratory did not appear, and nor were the typical records that are taken by the technician on site while a test pit is being excavated that shows their observations of the soil as that test pit is completed, and they can actually observe what the soil characteristics are, presence of waste, etc., and from what depth they obtained their soil samples if they took samples. That was not included. So I hesitate to even call that an investigation because we don't have the data. And to not have data revealed in a report is of this nature is also disturbing to me, because when the laboratory issues their records of the sample analysis, they also provide the precision, if you will, of their analysis, so that you know what is the smallest amount of a particular contaminant that they can identify. We have none of that data. So this report gave us kind of a broad brush overview, but nothing of actual scientific value, in my opinion.
And would, in your experience, have you seen a report where it did not have data? A formal report that did not have data?
No, no. Yes, I have read plenty of report summaries. They appear in many contexts, but not in a context like this, when it's a brand new investigation. It is done for the specific purpose of responding to comments provided on the draft EIS, and then presented in broad strokes. I could spend a fair amount of time basically, and I will spend a little bit of time for explaining why this Farallon summary report was completely inadequate. Just on the surface as a report, they said, we excavated 10 test pits. They only reported on 9 of them. Well, what happened to the other? They didn't give us the important information about those test pits that would provide the reader some understanding of the relevance of those test pits to the type of soils it revealed, where the wood waste was found at what depth, and so on. And likewise for the monitoring wells, those monitoring wells, they put the monitoring wells in 6 locations. 2 of the monitoring wells, in 2 locations, monitoring wells were side by side, shallow and deep. For the obvious reason of testing the water in the shallow aquifer as well as the deeper aquifer. However, as I mentioned before, one isolated sampling of groundwater at one point in time gives us a very tiny bit of information, but gives us no information about groundwater behavior. It tells us, based on the analytes that were chosen for analysis, it will tell us what contaminants are in the water at that particular point in time. But one single sampling event does not tell us which direction the groundwater is flowing, which is an extremely important piece of information if there are contaminants that could be moved in the groundwater. In effect, any soluble contaminant. It also, so none of that was provided. The other thing, as I mentioned before, 10 test pits over 100 acres, it is kind of like putting 10 pinholes in a king-size blanket. It gives us so little information that it's almost impossible to draw a meaningful conclusion from it, and scientifically would not be credible. You can't apply those 10 test pit, the information from 10 test pits to the entire 100 acres. Just doesn't make sense from a scientific point of view. Way too small of an effort. So planning area, and I find this interesting because the environmental analysis of planning area 1 is the least of the 3 planning areas. But planning area 1 is the only area within the EIS where proposed development is actually described. Interesting. So let me just sort of move here a little bit from my reactions
Can I
to
interrupt a little bit and just a couple of follow-up questions on those? So for the 10 test pits on the 100 acres, you say that is inadequate, doesn't give us a full picture. You provided kind of an example of another site where that was significantly smaller and had significantly more test pits. Would you say that the number of test pits that were on your example site are more in line with what would be expected for a report like this? Is there a recommended number of test pits per acre for a site that is this contaminated?
That's an excellent question. I actually tried to find answers for a question like that because back in the late 90s, I believe, Ecology produced a very good document on essentially the statistical probability of, I'm saying that the wrong way, on using statistical probabilities to design your investigation, and which is a great sort of starting point. It's not usually where most people start. The typical starting point is where do we know contamination is, or where do we think it might be? So neither of those approaches seems to have been applied in this investigation of planning area 1. The stated objective of this particular investigation was to determine whether contamination from planning area 2 in particular, or planning area 3, might be impacting or might in the future impact planning area 1. That's not a bad question to ask, but this investigation, though it claims to have answered that question, in my professional opinion, has not gotten there, has not adequately answered the question. It's an important question to ask because if planning area 1 is the first one to be developed and there is existing contamination in planning areas 2 and 3 that may have the ability to migrate into planning area 1, that's extremely important. But with so little information produced from this tiny investigation, from the point of view of the scientific research, this was inadequate to answer the question. For one thing, we need to understand what causes contaminants to migrate. The most common thing that causes contaminants to migrate is groundwater. Groundwater doesn't hold still in the subsurface. It may not flow at the speed that a river does, but it does move. Groundwater is essentially the occupation of water in the pore spaces between soil particles. And so that water is under the influence of gravity, of pressure, just like it is in a faucet or in a pipeline, although it's on a micro scale. So, and that's why understanding site-wide what is the groundwater behavior, and by that I mean what direction is groundwater flowing and what are the seasonal variations in groundwater flow and groundwater velocity. That study alone is big, but for this particular property is extremely important. The groundwater doesn't hold still. And understanding the potential as yet not understood connection between groundwater within this property and surface water bounding or very near the property is a huge question. It's more of a, simply put, are contaminants from this 261 acre site getting into the Snoqualmie River? That question is very important. Are contaminants from this 261 acre site getting into Borst Lake? That's another very important question because Borst Lake is not owned by the same owners as planning areas 1, 2, and 3. So the investigation that was done by Farallon and reported, the summary reported in the final EIS doesn't even come close to answering those two very important questions. And granted, for a property this size, answering those important questions is a significant undertaking, but extremely important.
So I'm hearing that there are too few test pits. Am I correct in understanding that your testimony is that there are too few test pits to understand the contamination on site 1? There's only apparently one sampling, and it should have been multiple over time to better understand seasonal variations. Would that be accurate?
Right. So there's two components here of that investigation. There was soil and groundwater. And they behave differently. Okay, so test pits can tell us a lot about what's going on in the soil. The monitoring wells that were installed tell us about what's going on, or can tell us about what's going on in groundwater. Each of those was sampled only one time. Okay, so from a temporal point of view, the groundwater analysis gave us one sample point in time, which does not give us any information regarding groundwater behavior, which I mean is movement and velocity, is direction of flow and velocity. Okay, and recognizing that direction of flow and velocity can also impact contaminant concentration in the groundwater. Okay, because that's a dynamic system.
Mhm.
The test pits tell us about soil. So what kinds of soils are there? What kinds of fill are there? What depth they occur at? And the soil samples that were then collected give us some clues about contamination in that specific area. But they don't, soil sampling, if I take one soil sample, or let's say I take soil samples from 3 depths in a 15-foot deep test pit, that gives me one piece of information at each sampling point alone. But it only gives me information that is relevant to that spot. Okay, I cannot extrapolate to even 10 feet away from that sampling point and say, oh, well, we found contaminant A here. We will find it also in this spot 10 feet away. It's just not how it happens. As you get, so until you actually can identify the source of the contamination, it's often very difficult to actually determine how do I begin? How do I begin this investigation of the subsurface, you know, that's been here for 100 years with some sort of industrial activity on top of it? But because the one thing the Farallon report indicated was that each of their test pits, they identified wood waste. And in other reports that that are already in the record and we've mentioned before, such as Delta Environmental, there is mention of the low-lying areas in planning area 1 and possibly the other planning area. I think all planning areas had some low areas that were filled in using wood waste, which is probably bark and wood chips, and sawdust, which this sawmill created a lot of over 100 years. So that's significant. I mentioned structural fill. That wasn't a very popular comment, so I won't follow up on that, but I do want to follow up on this, and that's the decomposition of wood waste in the environment, in a wet environment. Aside from the emission of methane that I talked about, what also happens with wood waste as it decomposes is that it can change the geochemistry of the area where it is. In other words, in that intersection of waste and groundwater. So wood waste tends to lower the pH. Let me see if I can get my science right on this one. Sorry. So as wood waste decomposes, the decomposition material is typically referred to as leachate, as the same as it would be from municipal waste landfill. So the leachate lowers the dissolved oxygen and pH in the groundwater. This produces what is referred to as a reducing condition, which means that it chemically causes some metals to become dissolved in the groundwater, whereas in a dry environment, they wouldn't be. So once they are dissolved in groundwater, they become mobile. That is a very significant issue when we're talking about subsurface contamination, because if there are naturally occurring metals, for example, in the subsurface that then become mobilized in a reducing environment, they can then become mobile contaminants and then if the groundwater connects with a surface water body, they can then impact organisms in that body of surface water. So in my research of the remediation of other mill sites within Washington, this came up actually at the Cashmere Mill site. And also at Port Gamble. And that was in both areas, they had done enough soil sampling to understand there was arsenic in the soil, which, and in the areas where there was wood waste, there was also elevated arsenic levels found in the groundwater. Now, interestingly enough, Farallon also noted that there was arsenic in their groundwater samples. Okay, they sampled those 10 wells one time and found elevated levels of arsenic. Arsenic is considered a contaminant. However, if it's naturally occurring, usually there are concessions, if you will, made by the regulatory agencies, depending on what the use or potential uses of the groundwater are in that area. So they they admitted they didn't know the source, they being Farallon didn't know the source of arsenic in groundwater, but because it was above Matka method A levels, it was of concern. So they posited that it may be naturally occurring. They also posited that it could be due to an up gradient source of arsenic lying off-site, but no name, no identification of that potential source or sources was given. I found that interesting because of the other mill sites that whose reports I examined in Washington, where arsenic was found in groundwater, but it wasn't elevated in the soil. A very interesting thing, and I'm just putting this out there as one of the possible results of having a large amount of waste wood in the subsurface in planning area 1 that is also in contact with the shallow aquifer. So that piece was not addressed by Farallon. All right, I think I've pretty well exhausted that topic, Audrey.
Yeah. Okay, so you've identified a number of gaps in the Farallon. I don't know if we call it a report, it's a summary. You said it doesn't have data, but I'd like you to relate that to the importance of the decision made by the city and how that relates to the EIS and why that is, how it relates to the decision made by the city and the EIS.
Ms. Carey?
Ms. Clutchin, I apologize for interrupting. I'm a little bit late with this objection. Again, just for the record, we can address this on cross-examination, a foundational objection to Ms. Jenkins' testimony to the extent that she's testifying on hydrogeology. I'm not sure what her foundational expertise is in that area, and I will leave it at that.
Thank you for playing by those rules. Mr. Sturbank, did you have something else to say?
I object. Maybe I misunderstood the question, but I object to the extent that it's assuming connection or relationship to something that the city did when I don't believe that's been testified to. So again, that'd be a lack of foundation objection.
Excuse me, Bob, I didn't understand your objection. Can you repeat that for me, please?
Actually, for me, I didn't understand either.
I was objecting to a lack of foundation. I believe the question was leading and suggested a connection between something the witness did or didn't do and what the city had done. I don't believe I heard that testified to.
Okay, that question I heard Ms. Clutchin ask was for Ms. Jenkins to extrapolate her concerns based on the lack of information to the EIS. I didn't hear her say anything about what the city had done except issue an EIS. Was there something else in there?
No, it was really the importance of why this information is necessary in order for this to make an informed decision on the environmental impacts of the project.
Okay. Mr. Sturbank, does that clarify?
Is she asking the witness if it is?
I'm asking the witness how it is.
So again, that's a leading question, but
I'm going to hear Ms. Jenkins' testimony about why this concern relates to her concern about the EIS.
The reason why it makes sense to talk about this is that Farallon did an investigation. I reviewed that investigation summary that was contained in the final EIS and found it to be too small, insufficient, not focused, and came to conclusions that I had no right to come to because there was an insufficient amount of data and the data was not even presented. So in terms of useful information, it was not very good. However, it did point out that there's arsenic in the subsurface. I went and it piqued my curiosity, so I offered these other experiences at other pulp mills in Washington where arsenic in the subsurface had been found to be the result of wood waste buried on site in contact with groundwater that produced higher than normal, higher than natural arsenic concentrations. That's important because arsenic is extremely poisonous, more poisonous to aquatic organisms than to many others. And because of the presence, the nearby presence of surface water, for which we have no information at this point between potential connection of groundwater with surface water, we have many more questions than we have answers. Investigations are supposed to find answers. My point is, Farallon's investigation did not. And furthermore, because we're talking about an investigation that was done to support an environmental impact statement, we are still left with lots of uncertainty. The environmental impact statement is supposed to cover the areas of the environment that are potentially impacted by the proposed action. From my scientific point of view, into the areas of toxic contamination in the environment, whether it's air, water, surface water, groundwater, or soil, which I do have lots of expertise in, the EIS does not present enough information to support what's been proposed, simply stated. The proposal is redevelopment of the site in 3 phases. The proposed first site to be developed is planning area 1. That is precisely the site about which we have the least amount of environmental data. So the reason I've been sort of dragging us through the weeds here is because science matters about contaminated sites. And if the science is bad, the following decisions may cause things to become quite messy in the future.
Okay.
Going back, I want to elaborate on my previous question. So, write down. You've identified a number of gaps in the study that you've described as important. And we were discussing relating them to the importance of that information to the decision made by the city. This EIS has been prepared to inform the city's decision on a proposed site plan. This plan proposes various uses on the site: commercial, residential, retail, and the location of those uses. We have that information. The density, intensity, infrastructure. Why is better information on toxic pollution on the site important to have before any decisions are made on what uses to approve and where they're located?
That's a $1,000 question, isn't it? The whole purpose of SEPA is basically to connect those decisions to an understanding of the environmental characteristics that could have impacts on future development. That's why it was invented. So the EIS process is supposed to bring is supposed to answer the questions about how can things in this environment, specifically contaminants, affect the decisions made about future development or future activities on this site. So the answers that are presented here for planning area 1, which is the only area for which I saw anything that's even close to a plan for development, is we still don't know anything really about planning area 1 in terms of environmental characteristics, about future contaminants that may impair the use that is being proposed in the development plan as it's been outlined in the EIS, which includes residential, retail, and some other commercial activities. If this issue of wood waste buried in the subsurface in contact with groundwater is producing methane, that is a potential problem for future people living on this area. If that doesn't get discovered until after those various apartments are built or the retail shops are built, there is the potential for fire and for people to be asphyxiated by methane. That's precisely why SEPA is what it is, to prevent those kind of bad things from happening. So the other thing that I believe SEPA is supposed to do is take the long-range view for proposed future impacts. In this case, we're talking about development impacts, a large development when you combine all 3 planning areas. And the plan admits that, the EIS admits that the plans for planning area 1 are far more advanced than development plans for 2 and 3, which kind of makes sense, maybe, because as I've pointed out, planning areas 2 and 3, particularly planning area 3, have significant areas of significant contamination. What this investigation done by Farallon did not tell us is what impact those existing known areas of contamination may have on planning area 1. Even though that was their stated objective, I am saying they didn't answer the question. The other thing that I found lacking, again, reading this for understanding environmental impacts, is there's almost no detail provided about the plans or even the guesses about how planning areas 2 and 3 will be developed, except very vague concepts like this will be commercial retail and this will have some light manufacturing on it. Well, that's not enough information for a SEPA EIS to evaluate any sort of future impacts. So
Were there any, did Faleron do any study of the contamination on planning areas 2 or 3?
No, they didn't do any further study. They summarized previous studies, and even that summary was not complete, as I think I pointed out before. They're missing some of the sites that are even included on their figures.
Mhm. But as you stated, there's the concern about how contamination from those areas could impact planning area 1, correct?
There is the potential,
Okay.
and it happens in 2 ways. Groundwater is the biggest unknown, okay, but I already mentioned that groundwater can be the conveyor of subsurface contaminants.
Mhm.
The other thing is that when excavation occurs, a lot of particulate goes into the air. If that particulate comes from an area of contaminated soil, you've just sent a whole lot of contaminants into the air as well.
Mhm.
Those can clearly affect people who are within proximity of that dusty disturbance, if you will.
Mhm.
So that puts construction workers at risk. It also puts people located nearby at risk. One of the questions I have about the CIS is why didn't they discuss, if, you know, looking at a phased development approach, if planning area 1 is developed first and they plan to do remediation after that development on the remediation that's required in planning areas 2 and 3. What about the downstream airborne impacts of that excavation? And it would require a lot of excavation in planning areas 3 and 2. You know, are they just, it's very difficult. I have been on remediation sites. It's very difficult to contain airborne contaminants during excavation. There are best management practices. Basically, you're supposed to run a sprinkler truck over the area being excavated. But in reality, what I have seen is that the air may dry much more quickly than they have enough water on site to keep everything sprinkled while they're excavating. So a lot of dust gets carried beyond the property boundaries.
Mhm.
That is a very real risk in a place where there are serious contaminants that have that can be injurious when they are inhaled. Dioxins and furans is one of those things.
We have an objection, Mr. Sturbank.
I'm sorry, perhaps more of a clarification. It's not clear to me whether the witness is testifying from her personal observation of other cleanups or that it's a possibility.
Okay, can we clarify, Ms. Jenkins? Were you speaking of personal observations from other observing other sites? Were you speaking of this potentially could happen, or how are you speaking of those things?
I have been on many remedial sites, and I have watched the operations. I have been on Superfund sites personally as an inspector. For example, a mine, a fairly large Superfund site outside of Kellogg, where I was supposed to be the certifier of mining equipment that was being hauled out of the mine, and it was supposed to have been cleaned before it was taken out. So I have been up close and personal and in the potential contamination inhalation zone on a remedial site for days. I've also watched construction of I have another project right now that's under construction where and I'm very familiar with all of the documents that have been produced on this site, including the jurisdiction's requirements for air quality control, and those have been completely ignored. I shouldn't say completely ignored. They do have a water truck on site, and the water truck driver occasionally drives around the site and sprinkles water on soil piles. but he has never kept up with the excavation. On this particular site, it's a 17-acre site, 17 or 19, and they have been running on average 8 to 11 excavators at a time. One water truck can't possibly control all the dust that is being generated. And this is Western Washington, it's not Eastern Washington where it dries really fast. But this water truck can't possibly keep up with the amount of dust that 11 excavators are stirring up 8 hours or more a day. So even though there are best management practices for air quality control on contaminated sites or even ordinary construction sites, they are not adequate for dust control. On that particular site, the one I just mentioned, the developers promised, actually the developers consultant promised that they would do air monitoring on the borders of the property to make sure that residents outside of their property boundary were not receiving contaminated dust from their excavations. They've never monitored anything. There's not a single monitor on the
Ms. Examiner, if I may intervene and just object, I think that Bob was fairly asking for a foundation, but we've gone down a whole nother path here of testimony that I'm not sure I understand how it relates to the issues at hand. We've heard Ms. Jenkins testify about her firsthand observances, but we've gone down very, very deep in that path at this point.
And I would add to the extent that that was Mr. Sturbank's objection was for foundation. I thought we were going to address that on cross too. So.
We are, but also with regard to Ms. Jenkins' testimony explaining why she has concerns about the current EIS, I understood the testimony she's offering is that her concerns are based on things she's observed at other sites.
And
is there an objection to that?
No, my only objection is just that we're going into such detail about other sites that don't have any relevance to the one at hand. I understand from her testimony that, you know, she believes she has experience and expertise in this area, and that's understandable to explain, but we're going down into a lot of detail about the specifics of sites that don't relate to this one.
Right. I find her testimony about the reasons why she's concerned is relevant, and I was going to let her continue. I think one thing that Ms. Carey didn't say, and maybe Mr. Sturbank too, is they're concerned about time. I feel like this might be going long, and so potentially, if we could, I don't know, I don't want to cut testimony short, but we do have a long list of other people who do need to testify. So I don't know if we could give shorter examples or be more direct somehow.
I think if I'm sorry to interrupt, but
Ms. Examiner, I'm sorry. Yeah, if we're hearing from council about the basis of the objections, I'd like to be heard for a moment, if I may.
Okay.
A foundational objection calls for, particularly from an expert, calls for them to provide some evidence that establishes that they have a basis to support the opinion that they're offering. At least my objection, and I don't understand Ms. Carey's objections, to be calling for, you know, the entire treatise on what happened every day at a particular site. We're looking at whether or not there's an evidentiary foundation or not. And beyond that, the details then become irrelevant, as well as it is 3 o'clock and this is still the appellant's first witness. We're almost through the day. So I am concerned about time, and particularly the other witnesses that are listed are almost exclusively experts throughout the case.
I think that you have given testimony about the reasons why you're concerned based on your experiences at other sites. I don't know if you have other things you'd like to say or that Ms. Clungeon wants you to discuss regarding this site and this EIS.
Okay. Yes, we have additional things to discuss. I understand that we are late in the day on the first witness, but this is one of the major issues. So I don't want to rush Ms. Jenkins. Mr. Sturbank raised an objection for foundation, and then there was an objection when she provided a lengthy answer providing that. So I just, I'd like to continue.
That's what I,
Okay. Great. So.
Right. I'm sorry that I beat a probably dead horse.
No.
Let me simply go back to the investigation that was conducted in Planning Area 1. That was part of the final EIS. And this is also a comment on the way comments were handled in the final EIS, of which I submitted a number of comments on the draft and feel that when they were all lumped together, the responses to those lumped together comments gave a general picture, but they missed a lot of specific points. One of the specific points I had made was there were railroad tracks across I believe the southern portion of Planning Area 1. And we know from investigations at many other railways that certain contaminants tend to accumulate in soil beneath or near the railroad tracks, including heavy metals and petroleum hydrocarbons. That was ignored when the remedial investigation of Planning Area was 1, and there was no investigation done at all in the area of the former railroad tracks. There's also nothing mentioned in that report that informed their decision of where to place their test pits or where to place their monitoring wells. It might as well have been a dartboard from all I can tell, except that monitoring wells were placed along the eastern boundary of Planning Area 1, which is the nearest boundary to the other 2 planning areas. There are other considerations when preparing to do an environmental investigation. You need to sort of think like a detective. Where are the contaminants likely to be? I didn't see evidence of any of that thinking that went into the Farallon investigation. It's sort of a historical review that needs to be done, saying, okay, what are the known uses of the known former uses on this property, and which of those may have caused contaminants to enter the subsurface, surface or subsurface. For example, we know that a lot of fill material was put into Planning Area 1, but the investigation did not answer what is the aerial extent of that fill. We also know from historical evidence that there were, I believe, 8 bunk houses built on Planning Area 1, which housed Japanese construction workers who were building the rail lines for the Snoqualmie mill operations. Those housing units are no longer there. They were demolished. And one of the older reports noted that the land was reportedly used for growing potatoes and as a conifer nursery. Well, where things are grown, very often herbicides and pesticides are put on those plantations. None of that, and many of the older herbicides and pesticides contained chemicals that are persistent in the environment. But that didn't seem to inform this investigation either. None of those type of, as far as I could tell, there was no placement of either monitoring wells or test pits in the areas where those 2 where the 2 planting areas were located for potatoes and for conifer seedling growth. In their report, there's no indication of the location of either of those two plantations, nor of the old bunkhouses. You know, in Western Washington, you need heat in the winter. What heated those bunkhouses? Was it heating oil? And if so, what happened to the heating oil tanks? Very often at heating oil tanks, we also find petroleum contamination in the soil from drips or from leaking tanks. None of that seems to have entered into the design of this investigation. If you're still thinking as a detective, you would go, well, gee, there were some large transformers located in planning areas 2 and 3. And we know about the demise of some of those, 3 of them right near the plywood plant, which burned. And we know some of the history of 2 other transformers that contain PCB oil and caused ground contamination. PCB transformers have been in use in industrial sites since, I think, about the late 20s. And then PCBs were banned from manufacture by EPA in 1979. So in the 80s and 90s, most PCB transformers, as they wore out, were decommissioned and disposed of. So in the 86 years that this sawmill operated, that's between 1917 and 2003, there were probably 2 or 3 generations of PCB containing transformers. What happened to the old ones when the new transformers replaced them? It was very common for that kind of equipment to be buried on site because we didn't have hazardous waste landfills back then. And Snoqualmie was far away from any of the existing landfills in Washington during much of that time that they were operating. So it's possible, and again, it's just possible. I'm not saying this happened or that I have any opinion about it. It's possible that that type of equipment was buried on site. And since they filled much or a significant portion of planning area 1, isn't it possible that such retired equipment may have been buried in that fill area? Those are the kind of questions that I ask if I am tasked with designing a remedial investigation. It appears not to have happened in this case. So what Farallon study does not tell us, and I have a list here, it does not tell us the lateral extent of woody fill in planning area 1. And I would also posit that under current ecology rules, this area could be named a wood waste landfill because it's a landfill made out of wood waste. And so that would actually put it under a different set of rules, just a note there. There were no precise groundwater monitoring well locations or soil sampling locations provided. So we don't know the precise location. What we have is a small diagram that has little marks that says this is monitoring well 1, 2, 3, 4, 5, etc. The reason why surveyed locations of wells is important is particularly in determining their location relative to other known locations, such as known areas of contamination, and also when doing elevation diagrams or analysis when you are looking at groundwater flow, groundwater behavior. The actual data from the laboratory were not provided. The actual soil contaminant data neither data for soil nor for groundwater was provided. There were no vertical soil profiles provided. There was no information on laboratory data quality or quantitation limits provided. So we don't even know if the laboratory tests that were done were at low enough levels of contaminant identification or contaminant quantification that they would be comparable to Ecology's Matka method limits. No photos of the test pits were provided. So Farallon offered conclusions, I believe, that may be premature on this site because it was a very small, very brief investigation, or even possibly grossly inadequate if they are generalized to the entirety of planning area 1.
Okay.
All right.
So in our your discussion of planning area 1, you identified a number of things that you would have considered, or a number of recommendations that were in the comments from the draft DIS, correct? Is that accurate?
Yes, comments in the draft EIS did not appear to get communicated to Farallon to help inform their investigation. We didn't know it was going to be an investigation, but you would think they could have used some of that comment information.
So,
Go ahead.
So is the report or the Farallon report or the response in the FEIS, did that adequately respond to the comments made regarding the need for testing and information for contamination that was communicated in the draft DIS, in your opinion?
No.
Okay. And those comments asking for additional information, is it your opinion that this report doesn't satisfy those requests?
Let me just clarify that the comments I made did not ask for, my comments were not anticipating that there would be an investigation in between the draft and final EIS. I just made comments like, hey, gee, your information in the draft EIS says there was contamination, that says there were railroad tracks across planning area 1. Well, what with that? Farallon didn't notice that and make it part of their criteria in the investigation to look at, to examine that.
Okay. Are you aware of other?
I'm sorry.
Are you aware of other comments that were submitted after the draft EIS that requested additional data or additional study of the contamination on the entire site?
Some of my comments definitely remarked on that. I think my remark was something to the effect of, hey, there's been no investigation done whatsoever in planning area 1, and that happens to be the area for which there's a development plan proposed. And then I went on to talk about deficiencies in what we know about planning areas 2 and 3. So,
okay. And I guess the next item would be, so if based on is the current information that we have about contamination adequate to make an informed decision under SEPA?
there's a number of decisions that can be made under SEPA. So
basically, can a decision maker make an informed decision about this proposal, this project, without the missing information?
That gets us into a bigger consideration of this entire process, actually.
Okay.
Because the development proposal is has its arms around all 3 planning areas.
Mhm.
So the best, there is quite a discrepancy in the level of proposed development, or let's say early development planning in planning area 1 than there is for planning area 2 and 3. In fact, EIS gives us basically no planning design or planning. They call it a concept, but it's a concept that can be stated in a sentence. You know, some retail commercial buildings, but for planning areas 2 and 3. So part of the function of an EIS is to evaluate future impacts of the proposal. Without knowing what that design is, it's impossible to predict what the future environmental impacts are. So for planning areas 2 and 3, we have nothing to go on. I think one of the I think it was the fellow Reidecke and Associates who did plants, animals, and wetlands or something like that. I can't remember exactly. But they very clearly, and this is in the EIS, said, hey, we don't know what is going to be, we don't know in enough detail what is like the placement of buildings or size of buildings or where the roads are going to be in planning areas 2 and 3 to make any meaningful determination of environmental impacts. And he was speaking to his area of expertise, but that is also relevant to every other area that's covered in the EIS. We don't know what's proposed for the future.
Mhm.
And so my understanding is that this EIS proposal is a phased approach, but if I take a look at what WAC 197.
Wait, can I just jump in? I didn't believe that Ms. Jenkins was going to be speaking about the FEIS proposal. We only have her listed for contamination in groundwater. So I'm being sensitive to the time. We are running really late. So
Okay.
Are you planning to have testimony from Ms. Jenkins on this? Because I don't know that it was within the scope. It's not been disclosed.
I mean, yes, to the extent that it the entire project has been phased, and it's been phased in a way where we have some information on 1, but we have very little information on 2 and 3, particularly with regard to any data or testing for contamination. So that's relevant in the context of understanding the impacts of the entire project. If this document is going to be used for future approvals, the phasing is definitely an issue here, and it relates to contamination too.
I'm just really getting very worried about the time at this point.
Mhm.
So I don't know if there's other contamination specific information that you want Ms. Jenkins to offer, if we can just wrap up.
Let me make this one final point, because I think it's extremely important from the point of view of SEPA. And that is the marriage of MOTCA, Model Toxics Control Act, and SEPA when there is remediation proposed on a site. And that, let me see if I can find the citation within the WAC. In my comments somewhere. In effect, for a site like this with extreme contamination, as in planning areas 2 and 3, MOTCA, I believe that what the WAC says is that ecology on the MOTCA side and the project proponent on the SEPA side, if you will, that's not really the right characterization, but there needs to be a discussion between the two, because there are environmental impacts related to MOTCA cleanup activities. And so that, I've got to find this citation. Audrey, maybe you can help me with this.
Are we talking about the SEPA MOTCA coordination?
Yes.
For remediation? So that would be WAC 197, 11, 256.
56 through 11, 268.
Correct.
So remediation of contaminated sites prior to redevelopment is subject to specific provisions of SEPA and the Model Toxic Control Act that must be coordinated through ecology as required in WAC 197, 11, 256 through 268. And this document says absolutely nothing about that coordination. I've talked to, when I was reviewing the draft EIS, I spoke with the program manager for toxics cleanup, and they had had no conversation regarding this site and its cleanup issues at all. So I don't know if any of that SEPA-MOTCA coordination has begun at this point. But I would say that in my opinion, this EIS is completely deficient in that regard, particularly regarding planning areas 2 and 3.
All right.
Okay.
Is that it, Ms. Clengen?
Let me check. I have potentially a couple other additional questions.
Briefly, quickly.
So based on the report or the summary that we have for planning area 1, is it possible that there could be additional contamination on that site that's not present in their analysis so far? It basically, is it possible that in this brownfield site that there is contamination that was not identified in Felleron's 10 test pits on a 100-acre site?
Yes, it is. And for these reasons, there was a railroad track across the site. That area was not investigated. And we know there are contaminants, soil contaminants associated with that. There is a large area that was filled. It's quite possible things were buried in that fill, such as old PCB transformers, heating oil tanks. What else? So yes, the investigation did not find that contamination, but it also didn't look for that contamination.
Okay. And one of the articulated purposes of the project proposal is remediation. They say that, well, this will remediate this site as a benefit. Based on the information that we have now, do we have enough information would an agency have enough information to actually go in and understand the extent of the contamination and adequately remediate it?
No, it needs more it needs a comprehensive remedial investigation done. From that point, then decision can be made about how remediation would happen. At that point, you can actually start to develop a cost figure for doing the remediation. And then you have some more data that may guide what you do in the future. And that piece, the remedial investigation and deciding how to do remediation, that's the piece that needs to be done in conference with ecology, particularly on such a large site.
Okay. What does a comprehensive investigation look like? What does that entail? And why is what is here not adequate?
Comprehensive would imply that there has been enough testing done of the environmental media, by which we mean soil, groundwater, and groundwater, if there are multiple aquifers, that would include sampling in those multiple aquifers, and understanding the extent, both vertically and horizontally, of such contamination. That needs to be known. And it won't be known exactly until basically this is where it gets tricky and intriguing. Okay, you find contamination, you almost always don't know what the full extent of it is until you start moving dirt. Rarely does it wind up being less than what you thought, in my experience. Particularly if it doesn't have a specific known source. Rogue contamination is how we used to call it. It's like, oh, there's this, once you have your groundwater samples in, oh, we're finding these contaminants in groundwater. Where did they come from? Which is why the direction of groundwater flow becomes an extremely important thing to know. If you can't find the source of the contamination, it becomes very difficult to remediate it effectively.
Okay. And is the possibility of contamination on areas 1, 2, 3, or the site as a whole sufficiently great that it needs more study now before any decisions are made to develop the site?
Yes. Yeah.
Okay. And let's see here. A lot of ground just catching. Not missing anything here.
I'm gonna suggest we go ahead and take a quick break, Ms. Clengen.
Okay. Okay.
I'm gonna. It's my intention that when we come back, we're gonna go to cross-examination. But we need to take a quick break, maybe 5 minutes, and then come back. I have counsel from the other parties. So did you come on to agree with me, or do you have other suggestions, requests before we break?
No, I'm prepared for cross-examination when we come back.
Okay, great. Mr. Sturbank?
Likewise, thank you.
Okay, great. Thank you very much. Let's just take a quick break. We'll come back and hopefully start cross-examination as soon as we get back. Thank you very much. That was a quick break. Thanks everyone for that. Ms. Clengen, can we proceed with cross-examination, or did you have any final questions for Ms. Jenkins on direct? Remember, you'll have an opportunity to redirect if you need to.
I think I'll say redirect. I think we've covered all the items here. So
yeah, your wrap-up questions were getting a little repetitive, so I figured that you had reached that point. That's why I kind of jumped in. So pardon me for that. So let's do cross-examination, and Ms. Carey is up. So please go ahead and unmute. And Ms. Jenkins, you are muted again. There you go. Great.
Okay. Thank you. Ms. Jenkins, I just have a handful of questions for clarification. I'm going to try to keep this brief. First, you had mentioned earlier on in your testimony the site ranking of 1. And I just wanted to clarify with you that this is out of a 1 to 5 ranking scale. It doesn't mean that it's number 1 in the state cleanup list, for example. Is that correct?
Yes, that is correct. And I'm sorry that I didn't make that clear. Yes.
Just wanted the clarification. Thank you. And I wanted to talk a little bit about your experience and understand some of the pieces of your testimony with that a little bit more. First question, what's your experience with sawmills? My understanding from your testimony is that you have not worked on a sawmill cleanup project before. Is that correct?
As far as I can remember, I have not worked personally on a sawmill remediation project. My experience is just review of other remedial studies that have been done or remedial reports.
And you haven't worked on any projects involving boilers, cleanup projects involving investigations or cleanups of boilers?
Actually, I have. When I first went to work for Ecology in the 90s, I was in the air quality program. And specifically, my job there was to be the permit issuer. They called it PSD permits, which stood for potentially significant PSD. Gosh, I can't even remember now. Anyway, it's a federal permit program and it involves any emission source that emits over 100 tons a year of air emissions. And so during that time, I did do review of boiler emissions for permitting purposes.
But you haven't done a MOTCA investigation and cleanup related to a boiler or boiler ash before, correct?
Actually, I have worked on sites where boiler ash was present. Yes.
Okay. And what sites are those?
Hang on just a second. We're talking about ancient history here. So let me just cycle back in my memory.
And just while you're thinking for the record, when I say MOTCA, I'm referring to MTCA, the acronym for Model Toxics Control Act, just so it's clear what we're talking about.
Yes. Hang on a second. This boiler ash question is going to poke me until I can remember.
And that's okay, Ms. Jenkins, in the interest of time, if you want to think about the specific examples and provide those in your redirect with council, that's fine. I just ask that you provide the examples.
All right, thank you.
Then with respect to PCBs, literally PCB for the record, what's your experience and knowledge of that contaminant? Have you worked on any MOTCA cleanup sites involving those?
Yes, I have, because it's actually a fairly common contaminant. And so on sites I worked on in Alaska, for example, I worked on for a number of years, actually, a site that it was one base. It was a military base that had lots of discrete contaminated sites. And we found PCB contamination in a number of areas, and we finally found, it took years actually to locate the source, which was buried PCB transformers that were in a very unlikely place. But there were other smaller pieces of equipment. I mean, that was the main source, but there were other smaller pieces of electrical equipment that also had PCB material. PCB was a constituent of material in those other electrical components that we also had found, like in one of the two landfills that we remediated. So yes, PCBs are fairly common, I would say, at industrial cleanup sites.
Are PCBs very mobile in media such as soil?
Relatively speaking, no. The PCBs tend, I need to couch my comments pretty carefully because soil is not uniform. So the behavior of contaminants in soil its specific behavior may tend to vary with the type of soil. PCBs are not what you would call a highly mobile contaminant in soil.
You mentioned having some experience with wood waste, and I just want to clarify the extent of your experience with wood waste. Have you been involved in any investigations or cleanups under MOTCA involving wood waste on a site?
No, but I have been involved in a fairly large remediation investigation that involved wood waste, but it was under RCRA instead of MODCA. It wasn't within the state of Washington, but it was under federal RCRA regulations.
And do you have any background in structural engineering, any training in that area?
No, that's not my professional training. I do overlap with geotechnical people when we're working on sites. So when we talk about the structural capacity of soil, it's something that I'm not trained in, but I've had conversations with geotechs that I'm working with on sites. And so I've picked up some knowledge there, but probably would not be considered an expert in that area.
Okay, so you're not offering an expert opinion on the structural integrity of the wood waste on this particular property, correct?
That would not be an expert opinion, but I don't think you would have an expert disagree with me.
Okay, but you're not offering an expert opinion, correct?
If I don't qualify as an expert in wood waste in the subsurface, then this is where it gets a little bit tricky. I don't know that anybody would call themselves a wood waste expert, but it doesn't take a lot of understanding of soil properties to recognize that a material that decomposes in the subsurface is not going to have equivalent structural properties to soil that upon which, okay, soils also have variations in structural capacity. So,
but just to clarify, Ms. Jenkins, so you're offering that factual opinion of yours, but you're not offering expert testimony on the structural integrity of soils at this site. Is that correct?
I'm not offering specific expert testimony. I'm offering you generally accepted information about wood, buried wood in the subsurface, which I have gained from my experience.
Okay. And then I wanted to understand better your experience in hydrogeology. Do you have a background in hydrogeology?
Only, again, what I have picked up in 30-something years of working on contaminated sites. Let me just say that working on contaminated sites, you don't have to be totally trained as a hydrogeologist in order to understand contaminants in groundwater, for example. So though I have worked with hydrogeologists a lot and learned from them, my expertise has come from being on the ground, assisting a drilling rig who's putting a well in the ground in a location that I may have selected or that may have been selected by a hydrogeologist. And the hydrogeologist examines the data and includes the soil properties and the capacity of the water bearing capacity of particular soils and things that are highly technical. I'm looking more at the contamination aspects from that drilling and soil sampling results.
Okay, but you are not a hydrogeologist, correct?
Mm-mm. Just understand there's a lot of overlap between environmental engineering and hydrogeology. I mean, all of it is interrelated.
Certainly. Thank you for that clarification. Okay, so then I wanted to ask you a little bit more about your conversations with individuals at the Department of Ecology, the Washington State Department of Ecology. You had mentioned that you had spoken with individuals there throughout this process at some point. Who have you spoken with at Ecology regarding this project?
And I've only had one or two conversations, so this has not been an extensive conversation. Let me see if I can find my phone notes. I think I mentioned that I've spoken with the program manager about this site when I was reviewing the draft EIS. And his name is he's no longer the program manager. That's, and I have not spoken with the new program manager for toxics cleanup. So let me just, I'm looking around my office for my old phone notebook, which may take me a minute.
Sure. And Ms. Jenkins, this may be another question that you can follow up on redirect with your counsel. As long as we get an answer to the question, I don't want to delay the cross-examination.
Okay.
Give you time to look for that. But specifically, I'm asking, who have you spoken with and when at the Department of Ecology?
Okay.
And to that extent, again, because I'm trying my best to be efficient here. Obviously, I would like to know if you have spoken with individuals there, what the content of that communication was. So if you can cover that in your redirect with counsel, great. Otherwise, I'd reserve the right to continue to ask a short line of questions on that.
Okay.
So I'm going to share my screen now. Sure. All right, can you all see that? This should be exhibit C2, and there's some yellow highlighting pulled up on that exhibit that I added to the exhibit. Can you see that okay?
We can see it. I wonder, is it possible for you to enlarge the size of it on your screen?
Sure, let me see.
Because that's
How's
great.
that?
A little bit, one more, perfect, great.
Perfect,
Thank you.
okay. So Ms. Jenkins, in your testimony, you mentioned that there was no discussion in the draft EIS or FEIS of boiler ash or the dip tank. And I've gone into, this is the draft EIS at Exhibit 2, and highlighted a couple of sections that do in fact address those areas. Had you seen these in before providing your testimony today?
I'm sorry, is this the draft EIS?
It is, yes.
Yes, and I forgive me if I misspoke. What I was referring to was the, hang on a second. There's a short summary within the FEIS, I believe, of, shoot. I've been questioned so much right now. I feel like my brain cells are swimming. Please forgive me. Let me just take a look at my notes here.
Well, I'd like to keep it really simple and straightforward just to address your statements earlier. This is the draft EIS at Exhibit 2, and it does in fact address the boiler ash, correct?
Yes, it does. What you show here on the screen certainly does.
Okay. And it does in fact address the former dip tank as well, correct?
Yes, the bottom pinnacle.
And I'm looking specifically here at this second highlighted area.
Oops, sorry.
Is this the appendix or is this the main body of the document?
No, that's a great question. This is the main body of the document, and I'm
Okay.
looking specifically at page 3-141 of that exhibit.
Thank you.
Thanks for the citation.
And just to be complete in running through this, this is page 3-142. Again, Ms. Jenkins, if you can just confirm, I'm looking at a sentence here that does in fact address the boiler ash as well. Do you see that too?
Yes, and I did, I believe, mention the same thing. So, yeah. I fear that I may have misreferenced. I can't remember right now the difference between what the draft EIS covers and the final EIS in terms of the known areas of contamination. And please forgive me if I flip those in that comment. So I didn't mean to mislead. So, and I appreciate you pointing out these citations. Thank you.
So certainly just wanted to clarify that. So then I'd also like to ask you a couple of questions about MOTCA generally. It sounds from your testimony that you've had experience on a number of MOTCA cleanups before, worked with the Department of Ecology. And in your experience, MACA applies to sites, to clean up sites, irrespective of the SEPA process, correct?
Yes, and some sites are cleaned up without having to go through an EIS process.
Okay. And so MACA's requirements are, binding on owners and operators, irrespective of SEPA, correct?
Yeah, the binding. Yeah, absolutely. Yes.
And in your experience as the Washington State Department of Ecology, are they the agency with the expertise and jurisdiction to administer MACA investigations and cleanups?
Yes.
Is there any other agency that is involved in that process?
Not directly, no. I mean, the reason I said that is because if the cleanup route is done through agreed orders and so on, the Attorney General's office is also involved. So it's not ecology operating by itself on many of these sites.
Thank you for that clarification. So the ecology in concert with the Attorney General's office to the extent that they're involved in that.
Yes.
Okay, thank you. And then along the way in your testimony, you had mentioned that planning areas 2 and 3, that a cleanup of those areas would require a lot of investigation. And I'm trying to make sure that I got your testimony accurate, because you're saying very affirmatively that it would require a lot of excavation. What's the basis for that opinion?
The basis for that opinion is the information that's contained in both the draft, well, in the draft EIS, as well as other documents that have been referred to previously that preceded the draft EIS, that show a lot of in-ground contamination, where there is an admission that they may not have gotten all of it. And the other issue is that some of the cleanups happened before MATCA was passed and before the cleanup levels were determined. Cleanup levels have changed a little bit since MATCA was established, because they're toxicity based. The science of toxicity also is evolving somewhat. And so from time to time, those MATCA cleanup levels will be adjusted, sometimes up, sometimes down. So the cleanup activities or remedial activities that were done before the passage of MATCA didn't have the benefit of those cleanup levels or of the process that's described in MATCA. So and in some of the reports, it admits that MATCA levels have, through toxicological information, they, for example, for petroleum hydrocarbons, the allowable levels in soil, allowable is not quite the right word, but the cleanup level in soil has actually been raised from what it was previous to 1990. So does that answer the question? Is that what you're looking for?
I think that's sufficient for my question for now. Yeah, thank you. The last question, I believe, from me, I'm going to share my screen again here. And we'll probably need to zoom in for everyone. Okay. So this is Exhibit C1. It's the final EIS, and I'm looking specifically at page 3-62. And you can see these words are highlighted just because I did a control find for it. But again, addressing the testimony that the boiler ash fill was not addressed in the FEIS or the draft EIS. I'm seeing here that the boiler ash was actually addressed in the FEIS. Are you seeing that too, Ms. Jenkins?
I am, but please be aware that there is outlined in planning area 3 a boiler ash pit, apparently a place where they took the boiler ash, and I don't know if it was technically buried or just placed in the ground, uncovered, I don't know. And there are, I think they're talking here about the possible use of boiler ash as fill material in planning area A, which I didn't mean. If I implied that, I did not mean it. There is a specific identified area in planning area 3 that has the words boiler ash in it. The fill I was talking about in planning area 1 this was only regarding my comments addressed only wood waste fill in planning area 1. I had not read anything about boiler ash. Several comments speculated about possible use of boiler ash as fill material in planning area 1. I don't believe that was one of my comments. It has been found, boiler ash has been found in a number of other sites that I am aware, that I have read about, not sites that I have worked on, where boiler ash was used as fill material. I think before they knew the toxic contaminants in boiler ash, this may have occurred.
But your testimony is not that the draft EIS and the FEIS didn't discuss the boiler ash or cover the boiler ash at all.
My testimony was, I believe, that the final EIS did not address the boiler ash pit that is identified in planning area 3. I believe it was addressed in the draft EIS.
Okay, thank you for that clarification.
I'm sorry if I just generated confusion here.
No, I appreciate the clarification. And so, Ms. Rice, subject to reserving the right to ask follow-up questions on the information that I asked for on redirect, that's the end of my questions on cross.
Great. Thanks very much. Mr. Sturbank, I assume that you also have cross-examination questions for this witness.
I have a handful, thank you.
Great.
A small handful, I should say. Ms. Jenkins, thanks for your time today on this. Ms. Carey was asking you about whether you're a hydrogeologist, and kind of went back and forth about overlap and working with other people on sites. You're aware, are you not, that hydrogeology is a separate area of licensure in the state of Washington?
Absolutely.
And you are not a licensed hydrogeologist, correct?
I'm a licensed PE.
But not a licensed hydrogeologist.
That is correct.
All right, thank you. Regarding the discussion of wood waste and structure, its ability to serve as structural fill and so on, have you, if part of your review, did you review the grading plan? This part of the planned commercial industrial plan proposal?
No, I did not.
Okay. Have you seen the site plan for the overall proposal for planning area 1?
A detailed site plan?
Yes.
No, I haven't seen that.
Okay, so you're not aware then, are you, that there are portions of planning in area 1 that are not proposed to be developed with structures?
Yes, I was aware of that there's quite a bit of open space.
Okay, and some areas that may contain wood waste could be in those areas that that are slated for reservation as open space, correct?
Yes.
Okay.
Yes.
And then I think you also were talking about hypothetical potential contamination in planning area 1, and you mentioned a railroad track and possible buried materials. You're not aware of specific evidence of railroad contamination on planning area 1, are you?
No, but my knowledge about the existence of that railroad track is from the draft EIS, and they referenced aerial photographs that they had researched when they were preparing that document.
Right, and those are not showing contamination on planning area 1, to your knowledge, are they?
No, you can't see contamination typically on an aerial photo unless it's affected the vegetation pretty dramatically.
And you also referenced the potential, I believe, hypothetical from your comment of buried material in the wood waste. I think you said equipment or transformers. You're not aware of specific evidence, are you, that there are transformers or other equipment buried in wood waste in planning area 1?
No, and that was exactly the basis of my question.
Okay, so that was a hypothetical question then on your
Well,
part.
it's a possibility that you, as a remedial site investigation designer, you will ask yourself these questions. Okay, where might that equipment have wound up? And can I structure my site investigation so if there is buried equipment there, that I will be able to find it? And there are ways to find metal objects without disturbing, without digging up the universe, using ground penetrating radar and other non-invasive techniques. So it's just part of, the questions that you think of as a detective about the history of the site. Where might this stuff have wound up?
Okay, and you're talking about asking those questions in the context, are you not, of a ecology supervised remediation plan?
No, not even. I'm talking about the questions that you would ask about, what's known about this site that might inform my remedial investigation plan, which then would get reviewed by ecology in a formal MOTCA process.
Okay, and you'd agree, wouldn't you, that ecology supervision and completion of a MOTCA process would mitigate concerns about contamination?
I'm sorry, that went too fast for my old brain to hear. Would you repeat the question?
Completion of an ecology supervised MOTCA remedial investigation and cleanup would mitigate concerns about contamination, would it not?
Sometimes the contamination does not get fully remediated, and ecology would probably be the first one to admit that there are cases where you cannot remove all concern, as you say. Either there are just difficulties that get encountered from time to time, and you can't get.
Ecology is the agency with the jurisdiction to make that determination, correct?
Yes.
Okay, thank you. I don't have any further questions, Examiner Rice. And
All
thank you
right.
for your time, Ms. Jenkins.
Yeah, thank you.
Okay, we'll go back to Ms. Clungeon, I believe. See if there is any redirect.
Just a couple minor ones. So there was a discussion about whether or not you've seen a detailed site plan. And I just wanted to, you reviewed the FEIS, correct?
Yes.
Okay, and then just maybe refresh, in the FEIS, do you recall if there were any site plans in that document that outlined the project?
When I think of site plans, I think of a stack of 24 by 36 inch drawings that outline, basically your plan of action. And I didn't find those. Okay, so here's a miniature view.
Okay,
Okay, great.
so does this look familiar?
Yes,
Okay, all right, so you did review this.
yes,
Okay, all right. And then you testified that Department of Ecology takes lead on cleanup issues, correct? Where is that?
that doesn't, taking the lead is maybe not the right
Okay.
thing.
Mhm.
Ecology has the latitude under MOTCA to allow cleanups to progress in probably basically 3 different ways. One is voluntary cleanup, where ecology is minimally involved. The second way is, I believe that it's through agreed orders, which is a semi-legal process that defines the steps for remedial, basically for remediation. And then there is a process that I'm less familiar with, which is totally kind of a top-down thing where ecology orders the site owner to clean up. And I don't really know what they call that process. I personally have not been involved with that one. It's just, it's lawsuit driven, basically. Not lawsuit, but it's all, instead of being an agreed process, it's much more of a thou shalt process through the court.
Okay.
Somebody has a name for it, but I can't remember at the moment.
Okay, so even though DOE is involved in this cleanup, you understand that the city is using this EIS for its land use decision, correct?
Yes,
Okay, and you previously testified that the EIS lacks critical info for the city that they should have before it makes its land use decisions, correct?
yes.
Okay. And does the fact that you agreed that DOE is involved in MOTCA undercut your testimony in any way that the EIS lacks critical information for the city's land use decision?
No,
Okay. Right, and so, all right, that's the end.
Okay, there were two other points that during cross by Ms. Carey, Ms. Jenkins said she would circle back to, and those were which projects she had worked on for wood waste projects, I believe, wood waste cleanups, and also who she spoke with at DOE when and regarding what topics.
I have boiler sites and
Did I get that wrong? It's boiler sites. Thank you.
but
No,
boiler
That's correct.
sites.
boiler ash sites. Yes.
So you guys have been peppering me with questions while I should have been trying to remember these things. So just a moment, let me just think about.
Well, can I pop in for a second, just in question issue of moving things along? I thought the idea was to give the witness time, which she hasn't had any time
Yeah.
to go back through. So
I think we should give her
yeah,
time
can
to
we
figure out her notes.
excuse her and then at a later break or first thing tomorrow morning, have her fill in those two pieces of information?
Ms.
Just
Carey,
keep them-
is it okay if that's tomorrow morning?
Yes, that's fine.
Okay.
Thank you.
Yeah, of course. We want accurate information, and we don't expect you to be able to get every piece of information out of your brain. Okay. So thank you, Ms. Jenkins, for your testimony, for being first on today's hearing. And I believe that concludes our discussion with you, except for those two last questions on redirect. So.
And Audrey, you'll give me an idea of when I should respond, when it fits into the schedule on those two questions. Okay, thank you.
Great. Thank you, Ms. Jenkins.
Thank you. Have a great rest of your day.
Take care. Ms. Clungeon, it's 4:11. You had said you were going to call some lay witnesses today. I assume we should proceed with that.
we certainly can. I'm not sure
You.
how many we can get through, but otherwise we could also reserve some for tomorrow.
After the experts that we've identified needing to go first, sure, certainly.
Yes. Okay, first one here, we've got Lacey Linney.
So I need city staff to promote Ms. Linney. Thank you so much. You are unmuted, but we still cannot see your video yet. There you are. Oh, nope, we can't hear you.
Can you hear me now?
Yes.
Okay, all right.
Yes. Ms. Clungeon, would you like to introduce your witness, or shall I just have her state and spell her name?
I'll have Lacey, you can introduce yourself.
Okay. Hello, my name is Lacey Linney, and I believe you want me to spell that. So that is L-A-C-Y. Last name Linney, L-I-N as in Nancy, N as in Nancy, E-Y. I am a resident of Fall City. I am also a participating member of the SCAN, the Snoqualmie Community Action Network board. I am here representing both the communities of the city of Snoqualmie as well as the larger Snoqualmie River Valley. And I just want to say thank you for the opportunity to speak at this. This is a first for me, so I'm learning a lot.
Please allow me to swear you in, Ms. Linney, before you testify. Do you swear or affirm your testimony will be true? If so, please say I do.
I do.
Thank you. And before you start, let me check in with council. Ms. Clungeon, are you going to provide questions as prompts for Ms. Linney to help us guide testimony?
Just a couple of questions, but I'll mostly let Ms. Linney take it away.
Okay, and do recall we had some rulings at the beginning of the hearing that did put a limit on the issues, and I just want to confirm Ms. Linney is familiar with those limits that I have imposed. So basically, Ms. Linney, you are listed as addressing flooding, and flooding has been dismissed as an issue. So please don't stray into that territory.
No problem.
Thank you. Ms. Clenchen?
Okay. All right. Hi, Lacey. Good afternoon.
Hi.
I'm just going to have you give just a little bit of background about your experience with the site and your involvement in commenting on the plan and the EIS and your role in the appeal and the issues that you've identified. So,
okay. So my history with this community group started probably within a week or a month of the DEIS being released. I think I saw a post on Facebook or some sort of social media avenue. I just started getting really interested in, you know, kind of the scary opportunity that was being presented as a development at this location, you know, just based on some of the historical references that they made, you know, related to Weyerhaeuser, as well as the cultural impacts that were there. And just really the approximation to the Snoqualmie River. I know it's not directly on the river, but it's on Mill Pond, which feeds Snoqualmie River, or vice versa. And I'm a resident of Fall City, so I am directly impacted by anything that happens to the Snoqualmie River. So I initially just got involved in—
Ms. Examiner, apologies, Ms. Linney, this is Courtney Kaler. I'm just going to interrupt here briefly. Ms. Linney, sorry, this is how the process works. I have to interrupt you on Zoom. So hopefully I won't need to do it too often. I hear already we're straying into issues regarding, I believe, stormwater impacts to the river that have been excluded. And so I just want to, you know, at the outset, that is not listed in the items on which Ms. Linney is going to testify, and also not an appeal issue. So hopefully I won't be interrupting here too often. I just wanted to raise that issue.
Apologies, I was just covering my historical references and didn't realize that I had gone into that space, so apologies. So skipping ahead, got involved commenting on the DI.
Sorry, I was muted.
Oh, yeah.
Sorry, I was muted.
Oh.
I was waving at you, but I was muted, so you couldn't hear me. I want to just say flooding was excluded, stormwater was excluded, and sewer was excluded. So those are three topics that are not available for testimony today. And I'm sorry, and please go ahead.
Like I said, helped comment on the DEIS, and then just became a participating member in the SCAN group and regular mill meetings. And then was asked to join SCAN as an official board member at the end of 2020. So I've been with the SCAN board for a little over a year at this point. Just because there were some members who wanted to move on and things like that. And then I have been helping the group, the larger group, you know, post on social media, just try to get the word out about the mill site and, you know, educate the community on what we perceive to be happening and an opportunity to, you know, participate in community events and potentially fight for something that you believe in and agree with from our perspective. I helped organize the appeal in December after the FEIS was released, and then since then I have been a main point person representing SCAN, engaging with the Brooklyn Law Group. Audrey, did I miss anything?
I think you covered it.
Okay.
All right. So let's jump into the issues that are still available. So start with light and glare. Identified where you can talk about that. So can you just tell us a little bit about what the issue is and what your and the basis for that and how it impacts you?
Definitely. So the Snoqualmie River Valley that parallels I-90 is a special region for outdoor enthusiasts such as myself. I've spent many mornings, many evenings on the mountains surrounding the valley, surrounding the Snoqualmie River. And the landscape is unique and it's very special and can be underappreciated by people who maybe don't have access to those same type of hobbies that I do. I'm one of many people who are concerned that another development along the river, again, it's not on the river, but it's in relative close approximation, will increase or will negate the natural landscape that so many of us appreciate, including denseness and darkness of the Snoqualmie Valley. I also think that a development of this location and this size will also significantly impact other outdoor enthusiasts, especially those who look to use the river and those that appreciate the wildlife, or the wilderness and wildlife as is along the Snoqualmie River. This specific location is will potentially be the largest of its kind within relation to the Snoqualmie River. It will create a significant decrease in night sky aesthetics, which could potentially affect the nocturnal ecosystem of the river. The topographic view shed that I reviewed, and I think it was in the DEIS, clearly shows that all the light pollution is estimated to be directed south and east for an approximate 7 miles of the Snoqualmie River, from the Salish Lodge approximately all the way to Tanner, as well as, you know, being seen almost from Mount Si. There's information available that clearly states that artificial lighting has a negative impact to the ecosystem along the river. I think that the sorry, looking at my notes. Neither the DEIS or the FEIS acknowledges any sort of this negative light pollution impact on the Snoqualmie River's nocturnal ecosystem. And I also think that they aren't really addressing what this size of a development will do to the Snoqualmie Valley as a whole, especially the outdoor community. Okay, that's all I have for light and glare.
Right, and another one of the issues that was raised in the appeal, I believe you helped draft, correct?
Yes.
Is noise and how
Yes.
that's in the EIS. Can you talk about that?
Yes. So most of the noise that I'm going to speak to is from road noise. I live, like I mentioned, I live in downtown Falls City. I actually live near the confluence of the Raging and Snoqualmie rivers. Our small community, unincorporated community, is building a park right at the confluence of these two rivers, which is directly across from Highway 202. The current noise from construction, gravel, and timber semi-trucks that roll through our town is already substantially noticeable for anyone working from home or experiencing the outdoors during the week at the park or the downtown area. The semi-truck traffic needed to support 15 plus years of development. I'm including all 3 stages of the development. I'm not splitting it up by any means. 15 plus years of development plus an estimated 6,000 truckloads of contaminated remediation will absolutely increase the semi-truck traffic using Highway 202 through Falls City up Preston Falls City Road instead of the Snoqualmie Parkway to I-90. My assumption is based on the fact that the I-90 Highway 18 interchange is also due for a construction remodel, and therefore people will be trying to avoid that intersection during that. I think that's a multi-year project as well. The increased traffic noise will both negatively affect my living space, my personal neighborhood living space, but as well as the community of Falls City, or really anybody in the valley who's looking to use the new park on the Snoqualmie River. You know, a lot of this road noise is tied to the length of the project, and the estimations on the length of the development, again, I say 15 plus years, is to me a little bit understated. And I think that when you are presenting something like this to the community, I think it's in your best interest to present them with as accurate information as possible. I do not feel as though the 15-year timeline is adequate, based on the fact that that was never, or that was set at the time of the DEIS, and there was never any consideration made for the additional remediation needed for the potential contamination of the site. So now we're talking about 15 years plus, who knows how long to do the remediation. I don't think that information was included in the FEIS either. There was no timeline or details describing what cleanup would look like. From my perspective, the community deserves to be informed about accurate estimations that will impact their daily lives when it comes to increased noise pollution from traffic. It's also going to negatively impact the natural landscape of the Snoqualmie River corridor with an increase in noise pollution. And as well as anybody who's using the valley for their outdoor sports, as I've mentioned again. Also, there's some information in the FEIS that describes the length of construction at 2 different timeframes, which I think is also confusing for a lay person as myself, and I'm trying to understand what that impact is to my community and help other people understand what the construction timeline looks like as well.
What are the 2 different time periods?
A couple comments make it a 12-month period, and another comment makes it a 24-month period. And those are both, I think those are both in the FEIS. I didn't go back and fact check to see if those were in the DEIS, unfortunately.
Okay.
That's it for noise.
Right. And then you also had some concerns about sort of infrastructure and related to the development. So can you talk about that?
Yeah. The infrastructure on this topic is unfortunately also a little bit tied to traffic, I would say. The location of this development is, from my perspective, difficult to get to. There's the Green Bridge, which is a 1-lane road headed both directions on Highway 202. Then you also have the 202 that is northwest of the Salish Lodge going down the big hill, which is a 1-lane highway both directions. It's windy. It's scary in the winter. There's no lights. And this development doesn't include any considerations for public transportation. There is no plan in the development or the overall project that would increase ridership, that would increase access from communities who are less advantaged to have their own vehicles to travel to the site. This is, by putting more cars on those 2 specific road locations, the Green Bridge and 202 between Salish and Fall City, you're increasing the odds of, or you're making our roads more unsafe the more cars that you put on the road. I have, from my perspective, you should not be building any developments. You should not be constructing any developments at this point in time without public transportation as a part of the conversation. And instead, the EIS, I think both D and FEIS state that this mitigation should be the responsibility of future owners at the commercial businesses at the mill site. It's on the people who buy the buildings to encourage ridership, and it's and they reference, having to go to King County and apply for permitting to have Metro come through that location specifically. But if you build that into your project, if you build in bus stops, if you encourage it from the get-go as a person of the community surrounding it, to me, that's more of an acceptable approach by just pushing it down the road and saying it's somebody else's problem. We have Highway 202 is going to struggle to support the increase in traffic that we're going to see naturally, in addition to a development of this size at this very specific location.
Okay. And have you already, a little bit about your experience with traffic in the area? now before the development. And
1 second, Ms. Clengen. Mr. Rogers.
oh,
My apologies, Madam Examiner and parties. Mr. Sturbank has lost power and is not presently in the meeting. He asked me to let you know that.
I did notice that he dropped out. Is
You
Ms.
wanna-
Astrachan still connected to power? She is.
Yeah.
Okay, great. Just wanted to, so we're okay proceeding without Mr. Sturbank, and assuming for this witness, is that true?
I believe so. Yes.
Okay, thanks very much. Thanks, Mr. Rogers. Sorry about that, Miss Linney.
No worries.
It's windy here too.
Yeah, it's an ugly day. Okay, so you wanted me to talk about traffic.
yes, just
Okay.
your personal experience with traffic in the area, because we're talking about infrastructure here. So
One of the biggest traffic problems that we have on Highway 202 is during the summer months when the river floaters come to town for weekend adventures on the Snoqualmie River. And it is, I mean, there is traffic backed up for probably a mile on the highway, on Highway 202. You have people walking around. There's no plans to address a widening of 202 that I'm aware of at that location.
Ms. Examiner, my apologies, and Ms. Linney, apologies again for interrupting. I don't see traffic as one of the items that Ms. Linney was going to testify about, and we seem to be heading perhaps quite a ways down that direction at this point in time.
So my understanding was this was aiming at infrastructure and the lack of infrastructure. I do understand it does incorporate traffic. So obviously the appellants are going to present a traffic expert, and that person will cover traffic expertise. And so Ms. Linney was giving testimony from her personal experience in the location. As long as you don't stray into areas that should be considered traffic engineering or traffic expertise, some amount of that would be allowed, but we do need to be mindful of the time.
Okay.
So you're talking about infrastructure.
yes.
Highway 202, river
Okay.
floaters.
Yes, it's really going back to the idea that the more cars you put on the road, the more it'll get unsafe. We already have an existing problem with a congested area down from the Salish Lodge. That really was my point that I was getting at. I also, yes. I also know that the Snoqualmie area in general is struggling with providing public transportation for some other locations. So it would be nice to see a push both from the city and the developer to try to encourage more public transportation for that region.
Okay. The outline. If so, do you have any kind of concluding comments or any?
You know, I did want to mention a little bit also about expanding on, and maybe this isn't appropriate, but you can let me know, from an infrastructure perspective, the amount of road improvements that are needed for the development to, I don't know what the right terminology is, to be successful. I think I counted in the FEIS 13 road improvement projects that needed to be completed to make sure that the community could be supported in a safe way from a transit perspective. And